Good afternoon and welcome to the Appellate Division First Department. Happy New Year. Today we have more than 7.5 hours of time requested for oral argument. So as you can imagine, all of us want to go home before midnight. So I ask you please, when I call your case and you stand up, please indicate to me just the amount of time, the minimum amount, the maximum amount of time, or from my perspective, the minimum amount of time that you need to make your salient points. We've read your briefs. We've read the record. If we want to ask more questions, we will, and this is always a hot bench here, so don't worry about that, okay? And I want to just let you all know that one of our judges, Judge Gonzalez, is appearing remotely. So we'll keep an eye on her and make sure that if she has any questions, that you're able to answer them too, okay? All right. Number one, People versus Angel de Jesus, submitted. Number two, Cruz versus New York City Housing Authority. 6, 2, and 5. C. Kalin is submitted. Romero versus Middleton. 5, 2, and 5. People versus Ronaldo Peguero. 5, 2, and 4. Corbis Capital versus Strand Hansen.
Appellant requests 6 minutes and 2 hours.
I'm going to give you 6, 1, and 6, okay? Dougherty versus City of New York. 5, 2, and 3. Fannie Mae versus Monegro. Respondent has not appeared. Would you like to submit? You may. Why don't I give you 2 minutes, okay? Milne Travel Agency versus Altour, Delaware. 5, 2, and 5. People versus Bernardo Ramos, submitted. Jackson versus Laconia Nursing Home. Appellate. 5, 2, and 5. People versus Lucas Almonte.
People request 5.
Yeah, I think 5, 2, and 5. La Cruz versus Memorial Sloan Kettering.
Appellants 4 and 2 minutes, please.
4, 2, and 4. Park West Executive Services versus Gallo, Vitucci, and Clark. 5, 2, and 5. People versus Daniel Young, submitted. Will of Stanley Walker. Okay, 5, 2, and 5. In the next case, Barnes versus Mount Sinai, both myself and Judge Kapnick are recused. Judge Hagler will come in, and it's going to be a big shuffle, so I think I will take that case first. So let me just ask you for the time you'd like. Okay, 5, 2, and 5. And we're going to take it out of term and have you come first, okay? People versus Jarrell Cornelius, submitted. Mangual versus New Life School, submitted. Okay, so the first case for argument, Barnes versus Mount Sinai. Please step up.
Good afternoon, Your Honors. I'm Judy Shamitzi from Wilson-Elser for the appellants. Here to respectfully request that the order on appeal be reversed for two reasons primarily. One is that the operative report, the contemporaneous operative report, as well as the surgeon's testimony establishes that on visual inspection, he saw, because this is the kind of surgery where you lift out the section that you're operating on, he saw with plain eyes that he had in fact closed the entire site of the anastomosis. So to argue otherwise is entirely speculative, and to do so, especially based on labs that only reflect the patient's condition after the surgery, to argue that that intraoperative departure occurred is speculative and therefore raises no questions.
Well, let me ask you something. In this case, we have Dr. Feingold, your expert, who's a colorectal surgeon, and the plaintiff has Dr. Mayer,
Yes.
who is a colorectal surgeon.
Yes, Your Honor.
So we have two specialists in their fields, and you don't seem to have a problem with Dr. Feingold's understanding of the pathology report that's central to this case, namely the report generated after the second revision surgery when the anastomosis failed, or had leakage rather. So we're looking at what we call well-circumscribed defects. So now we have two experts looking at the exact same pathology report, but have different opinions about what that term means. Is that a fair understanding?
I wouldn't quite characterize it that way, Your Honor. I think it is fair that they each have specialties.
So if that's the case, then if good enough for Dr. Feingold to be sufficiently expert enough to be able to look at that finding and give his spin, nothing personal, then there's no difference in Dr. Mayer looking at the exact same report and relying on that finding. He's not substituting his expertise for that of a pathologist and saying, well, I think that defect is a result of a misfired staple, arguendo. And when you look at that together with the decreasing values of the hemoglobin and hematocrit and the reduced RBC, red blood cells, and of course the white blood cell count, again, when you compare preoperative and postoperative, why doesn't it make sense that it's a triable issue of fact?
Let me take the path part of it first, if I may, Your Honor. I think that both of the experts are fully qualified to read a pathology report. I think that's fair game. That's what they're supposed to do as surgeons. What they are not supposed to do, however, and this is why we had the pathologist on reply,
Well,
is
but why didn't you do that when you first made your motion?
because my surgeon says, I read the path report, and this is how thick the pathologist determined the tissue was. I'm accepting that finding. That thickness is neither too thin, they said it's both too thin and too thick to do the anastomosis there. That thickness is just right. It's like the bears. It's just right. That is accepting the pathologist's finding, going no further than a surgeon normally would in relying on what the pathologist has determined the tissue has shown. That is fundamentally different from saying, the tissue looks this way, it has a well-circumscribed defect, fine, and I know how that occurs in tissue. We're not talking about looking at a tear that you look at in an ER, well, this looks like you cut it with a knife or something like that, something that you can see with your plain eyes. So we're talking about a pathologist under a microscope examining very small pieces of tissue and saying, tissue comes to look like this under this or that circumstance. And my pathologist, only because he's been called upon on reply, says you actually can't make that determination. You can describe the defect, but you cannot argue backwards how this tissue comes to look that way.
And
Which
what
is-
about my colleague's question about the post-operative decline, that part of the question, that there were signs that things were not going well?
So, yes, there are actually no signs that anything is going wrong until 2 days after discharge when he crashes at home. About the labs, I appreciate the argument that there are, in fact, and I have no issues with the record, of course, there are declining lab values, and those are the lab values that the plaintiff's expert has identified would show if you have blood loss. What he has not dealt with, or other than conclusorily saying, no, it can't be that, is the fact that the values are going down. My surgeon is saying it's because he's getting a lot of IV fluids, and it basically dilutes his labs. They're going down, they start to plateau, and when he is readmitted after he crashes at home, those values are better. And what has not happened in the interim is he has not gotten any blood.
Okay,
But what he did get, I'm sorry, Your Honor.
that's okay. You can pick up on rebuttal.
All right, thank you, Your Honor.
Good afternoon for Respondent John Barnes, Marvin Furman from Wolf and Furman. With regards to the pathology report, we have two experts here, as you pointed out, both board-certified colorectal surgeons who've done this surgery. Dr. Meyer has done this 1,000 times, and he's indicating his interpretation, just as Dr. Feingold is. And it's not just reading the report. If you look at the pathology report on 5641 of the record, it actually indicates the anastomosis, where the colon and the ileum are attached, is attached via staples, quote unquote. It then goes on to describe that there is a well-circumscribed defect. This is a classic issue of fact. One surgeon says that the staples must have opened, and the other surgeon, my expert, says no, it says it's attached, but this is a well-circumscribed hole. In addition, the record from Mount Sinai is clear that this man is bleeding. There's a clarification note issued by the resident on page 773 of the record where he indicates, and I'm reading it, patient has acute blood loss, anemia, based on drop in HH, hemoglobin, and hematocrit. He's bleeding and nothing is done. Dr. Chesson, the defendant surgeon in the case, the same day on October 24th on 768 in the record indicates that the patient is stable, again reading from the note, with only issue being drifting down of hemoglobin. It was recognized he was bleeding. It was recognized Mr. Barnes' hemoglobin was dangerously going down, yet nothing is done. Dr. Meyer describes that the first postoperative day when his hemoglobin goes from 14 to 9.5, that's 4 units of blood my client's lost. By the time he's discharged on the 26th, his hemoglobin is 7, which Dr. Campton, the resident, testified is the threshold for transfusion, not for discharge. And 2 days later, he's back in the hospital. We know he has a leak. During those 2 days, he's got abdominal complaints. It's in the ambulance call report when they take him to the next hospital 2 days later that he's been having abdominal complaints for 2 days. There were notes of blood in his stool, and clearly he has a bleeding leak of his anastomosis, which then leads to a 6-week hospitalization in Montefiore, a decline in his kidney function. He needs hemodialysis. He's now bleeding from his small intestine or duodenum. After that, he has another 7 admissions to nursing homes and hospitals because of all the complication that ensued, and not recognizing that he was bleeding during the 5 days that he was at Mount Sinai Hospital. The fact that his hemoglobin, hematocrit, red blood cells went up a little at Montefiore is explained as a hypovolemic state. He had been nauseous, he'd been vomiting, he's not getting fluids. In fact, he didn't get fluids for the last 2 days while he's at Mount Sinai. So the volume of fluid in his body goes down, so the hematocrit, the percentage of red blood cells will go up. However, even though those values go up at Montefiore, they're still abnormal. He's still anemic. He's got an oxygen saturation rate in his venous blood of 27%.
Counsel, you heard your friend make a point of saying that it was appropriate to, in motion practice below, to have attached the pathology affirmation in reply. Do you have a problem with that?
Well, I did object to it in the brief. However, if you read through both the pathologist, Dr. Lagana, and Dr. Feingold's subsequent affidavit, it just leads you back to this is a factual dispute because they're now interpreting the pathology report without having seen it, without having gone to the microscope, just as Dr. Meyer is. A colorectal surgeon, this is a big surgery, removing 17 inches of colon, 40% of your colon to remove these non-cancerous polyps that he had. It's a big surgery, and any colorectal surgeon is going to have to interpret that pathology. So while we did object, I think it just brings us back to a issue of fact, and I respectfully request that the court below's decision be upheld. Thank you.
Your Honor, the difference
Counsel-
between the clarification, I'm sorry, Your Honor, please.
Notwithstanding the pathology report, I don't know how you address the reports of the hemoglobin going down to a 7, which the doctor testified, as we just heard, would mean that he needs a transfusion. Why isn't that a deviation?
Because it goes from 9.5 to 7 and then up to 10.1 when he
When
gets
is it
readmitted.
10.1?
I'm sorry, Your Honor?
When is it 10.1?
It's 10.1 on the 28th when he's readmitted, and he hasn't gotten any blood.
So counsel, on the 26th, why would a doctor discharge a patient knowing that the patient would need a transfusion? Whatever happened later would be a subsequent act or some other intermediate act that occurred, intervening act that occurred. But at the day of, that they're talking about on the 26th, it was hemoglobin number of 7, which I didn't see any controverting testimony or expert testimony saying you should discharge a patient when they're in need of a transfusion.
There is, Your Honor. Dr. Chesson testified in detail at his deposition, explained why those numbers are going down, and that ties into the residence note, right, who's, I think she's a first year. She thinks, as the plaintiff's expert does, this could be because of blood loss, but what it actually is, and we know this for a fact, because again, he doesn't get blood. The only way this is gonna go back
Isn't that
up
at
is if
least
he
a
gets more
question of
blood.
fact? One doctor says that 7 requires you remain in the hospital. Another doctor says, Dr. Chesson himself says that it's not a demarcation that would require care and treatment.
Your Honor, what I'm talking about is it actually, as a causal issue, as a matter of causation, what is happening to him in that moment, the reason that the hematocrit and hemoglobin are trending down is because he is getting IV fluids, which Dr. Chesson knows and testifies to. And that is why he's not keeping him, because he also sees that it is starting to trend better, and in fact, when he's readmitted, it is better, and this is why. Because he's no longer getting fluids, but he didn't get any blood. There's no other way for it to go back up unless you get blood, or it turns out you didn't have a leak and we're no longer diluting your values. So that argument, that is the reason that doesn't hold.
Okay, thank you so much.
Thank you, Your Honors.
Thanks. Okay, Cruz versus Housing Authority. Step up.
Good afternoon. May it please the court. Seth Kramer for Appellate New York City Housing Authority. There's no dispute in this Article 78 proceeding that a challenge to the termination of the Section 8 subsidy would be time barred. The T3 notice was sent in October 2018, and that's the final determination that triggers a statute of limitations under the Williams consent decree and pursuant to the Court of Appeals decision in Banos. Following
That T3 notice had an indication to the petitioner that she needed to file something within 4 months? Was there a time, was that on the front of that T3 notice?
The T3 notice is an exhibit to the Williams consent decree. So NYCHA uses the form that was approved in that consent decree. I don't believe that that notice, that language is in the exhibit to the consent decree, and it wasn't, so it's not in the T3 notice because it's not in the exhibit.
There's really no dispute by the petitioner that she did not comply with the requirement to put in what she needed to put in to save her tenancy, and that she was really late in terms of the initial termination. She doesn't challenge the termination.
Correct.
What's going on here is that she keeps trying to come back with what's been characterized as negotiating to try and get back in through successive emails, letters, various other communications. Am I correct?
Correct, Your Honor.
But the bottom line is based on the original consent decree that it's clear for purposes of Section 217 and Article 78 of the CPLR, the determination to terminate a subsidy shall in all cases become final and binding upon the receipt of the notice of determination, which is what happened back in October 2022, correct?
Correct, Your Honor.
So, but then why isn't the request for reconsideration the time period running anew?
Because that would eliminate all the benefits of repos from the statute of limitations.
So in
Someone
other
could
words, like
make
10
a
years later, you could
request
say,
reconsideration.
please reconsider my application, and there would never be a statute of limitations in that.
Correct, because the analysis is the same. And when someone's requesting to be restored or requesting reconsideration, you're going to be looking at the underlying facts of the underlying determination.
Can you
Is there-
start a new, I'm sorry, can you start a new process? Can you apply anew? Or is it a one and done type thing?
There's no bar to, I'm not sure under the Section 8 policy. I know in public housing, there's some restrictions on eligibility if you're terminated. I'm not sure what the Section 8 policy is in terms of new applications.
Is there anything in writing to the tenant that seeking restoration does not toll the statute of limitations?
No, Your Honor, there's nothing in writing on that point. They've been terminated. It's like any, you're presumed to know the law and to know that you need to go to court.
But as you're going through the process, as they're asking her for further documents for her to substantiate her income, there's nothing that indicates that, as the original termination indicated that you have 4 months to go to court, this process, there's no guidance.
Correct. The Housing Authority, it's a process that can occur well after the statute of limitations expired. In this case, a couple of years later, if someone wants NYCHA to take a second look at a determination, that can happen, that can happen years later. Just to clarify also, the idea of submitting income documents, there's two aspects of submitting income documents here. One was the underlying determination that they failed to recertify, and that was the basis of why restoration was denied initially, is because they didn't comply with that requirement. But there's also a requirement for reconsideration, for NYCHA to even reconsider it. It's on the last page of the restoration form that you have to submit income documents to confirm that you're eligible, because NYCHA is not going to review a restoration request, look at the underlying determination, and then maybe the person's not even eligible anymore. So that's the basis for that. And we say in our papers cases where there's negotiation or meetings being held with the eventual petitioners following the determination, that doesn't extend the statute of limitations. And the administrative plan is not, that's what's focused on in the brief on appeal.
Is it the same administrative plan that took place earlier? It's a different plan.
Yes, the current plan, 2025 is the first time the administrative plan included a reference to restoration request, and it's not the equivalent of the kind of statute in Feller or, which required reconsideration and says should be considered the same as the original application. I'll address the other.
Thank you. Counsel?
Good afternoon, and may it please the court. Noah Foster, Legal Aid Society, the attorneys for the petitioner respondent, Selenite Cruz. At its core, this case is about judicial oversight of an agency's arbitrary and capricious conduct. Ms. Cruz is a longtime public.
That's generally what an Article 78 is,
Yes.
right? But here's the, here's the crux. She gets denied. I'm sorry, she doesn't put in her paperwork, and for a number of years continues not to put in her paperwork, and so she doesn't get her subsidy. And then she gets a notification. The notification says, this is final. If you want to appeal it, you've got 4 months. We agree on all of that, right?
On the initial termination.
Yeah,
Is
yeah.
that what you're?
So what is it that makes you, what is it that you think would permit her to reopen it and start the statute running anew? Because essentially, as counsel argues, that means 10 years from now, she could seek to reopen it and start the statute, and we'd never have a statute of repose.
Right. So the restoration process, it is a separate process from the termination process. It requires separate paperwork, a separate packet, and it's a separate determination as is shown by
Separate
them
determination in terms of what?
from the termination,
From the termination for
the
failure?
original termination.
Okay. So when you put it, when you seek to restore, is there hearing? Is there, what's put in that's different from your initial application for benefits?
So it's mostly the packet itself. There's
It's the same
ongoing
thing, right?
income
It's not like you're
requirements.
just saying, I'm sorry, I missed it. Here's my stuff, it's late. Is there anything else that's done?
Not that I know of, no.
So it's basically just, I missed it, here's the same documents I would have put in if I had been timely. So no new procedure, and the same documents as the first one.
Yes, Your Honor, but NYCHA is continuously steering tenants, including Ms. Cruz, to follow the restoration process.
Well, I'm sure they don't want her to lose. They want her to have stable housing. We all want her to have stable housing, but, so, sure, but you can't fault NYCHA for encouraging her to seek to restore.
And I'm not. I appreciate that they have encouraged her to seek to restore. However, their ongoing communications with her were telling her to keep submitting more and more documentation, and their final
So
denial.
are you saying that misled her to think that in fact she was going through this process and the statute therefore should be told?
No, Your Honor, I don't. I think this is a separate statute of limitations from the.
This argument that you're making now, that it's a whole new trajectory,
Yes.
was that made in your Article 70, but before? I don't know. if
Yes, it
made-
was made in the lower court.
In other words, you argue that this new thing under the 2025 administrative plan is a totally new process, legally mandated, totally independent. You've raised that early?
No, Your Honor. We
So this
raised
is-
it
so then
as
it's not
further
preserved.
statutory and case law support for our argument.
So it's not preserved then, if it wasn't raised?
Okay, I mean,
Counselor,
if,
I may,
yes.
I'm on the screen. Was there any argument made that the requests for additional documentation were unreasonable, that in fact your clients had truly satisfied the income affidavit requirements and so on?
Yes, Your Honor, I believe again, during the restoration process, Ms. Cruz complied with what NYCHA asked of her. There
No,
were
that's
more
not
than
what I'm
100.
asking.
Oh, okay.
That's not what I'm asking. The requests were numerous for additional documentation. My question to you is, at what point in time did she actually satisfy and meet her obligation to provide income affidavits or income information?
During the restoration process, is that?
Well, that'd have to be, right?
Yes.
Because
Yes,
she
yeah,
didn't do it
okay.
initially, so it would only be during the restoration
I
process.
believe there were 4 attempts, right?
Yes, and
So at which point does she actually do it? attempt number
Well,
4?
over the 4 attempts, they kept asking for paperwork they already had, as was shown in the responsive documents that are attached as exhibits to the original Article 78 petition.
Okay, thanks.
Thank you.
Counsel?
So for the reasons we stated, we don't believe that a request for restoration should reset the statute of limitations.
Although now it would, right? Because the regulations have changed.
No, I don't, that's
So
what.
you don't even think it would now, aren't the regulations different now than when the petitioner sought restoration?
When you're saying the regulations, you're referring to the NYCHA administrative plan?
Right.
The NYCHA administrative plan is its policy. The case law that was cited to suggest that the statute of limitations would get reset is based on a statute, and that statute wasn't even just saying consider reconsideration, consider a subsequent attempt. That statute actually said that the renewal application was required to be considered as though it were the original application.
So that's what I'm saying to you.
That's
That now, if she had done it now, that might start a new statute.
But that's not the equivalent of what's in the administrative plan, is my point. The administrative plan doesn't say consider the request for restoration as though it was the original request or an original, or as though it was submitted before the termination.
Oh, so your argument is that that new statute doesn't change your argument at all?
Right, it's not a statute, just to be clear. It's the policy
Right,
set
right,
forth in the administrative
right.
plan. But correct, it doesn't have the kind of language that the court looked at in the Feller case.
Okay,
Thank you, Your Honors.
you're welcome, thanks. Romero versus Middleton?
Good afternoon. Colby Forrest for Pollock, Isaac, and DeSico for Plaintiff Appellant. So we are here to respectfully request that the order of the lower court be reversed. Specifically, it is our position that the trial court made a credibility determination when reasoning that the plaintiff's testimony.
Well, let's start with what we all think is undisputed, right? That this was a rear-end collision,
Yes.
right? Okay, so automatically, rear-end collision, your guy is at fault.
Sure.
So we start at that. Other than that, what do you got? That's the stat. Our case law is pretty clear. Your guy rear-ended the truck.
Correct.
And so he would not have a cause of action. So why is it that you think that he does have a cause of action? Your guy's on an e-bike, right?
Yes,
Okay.
correct. He was on an e-bike, and then, as you said, he rear-ended the truck. However, plaintiff testified that as he was approaching the truck, and he was approximately 4 meters or about 13 feet away, the truck moved to the right-hand side.
Which put him in the right, correct?
He was
he
on
in
the
a
right-hand
right
side,
hand? Now, was he in a special bike lane that would have allowed him to go on the right-hand side?
No, plaintiff testified that there was no bike lane on this.
Correct. In other words, so on what basis would he have been to go on the right, you see, if he was in the right-hand side and not directly behind the truck, contrary to an eyewitness that saw him directly behind the truck, hitting the truck, putting that aside, on what basis was he on the right-hand side under those circumstances?
He testified that he was intending to move along the truck upon getting to the.
But I think what my colleague's trying to say is that even that is negligent.
Right.
There's no non-negligent explanation because the vehicle and traffic law, the parts of the vehicle and traffic law that would permit him to try and pass on the right are not applicable here, correct?
Correct.
So even if we accept his version of the offense, he rear-ended and his attempt to go right would violate the vehicle and traffic law. So what non-negligent explanation could he have?
I mean, we would just say that if plaintiff's version of events were to be
He's
believed.
still negligent because he passed in against the provisions of the vehicle and traffic law, right?
Sure.
All right, thank you.
Good afternoon, Anthony Bono for the respondents. May it please the court. I think the court below made the correct decision here with respect to the plaintiff's actions as being the only reason that this incident occurred. This is an undisputed single-lane roadway. The case law that the plaintiff primarily relied upon deals with multi-lane roadways, highways, where there's an alleged sudden lane change, which constitute a non-negligent explanation. That's well settled. Here it's completely different. We have a single lane of travel. The plaintiff admits he knows there's a red light ahead, makes no effort to stop, admits he's not planning to stop, intends to pass my client's truck and the other car ahead of it along the right side.
Wasn't there an eyewitness who put in an affidavit, Mr. Beach, saying that he saw your client's car stopped, the truck stopped?
Absolutely,
Saw
yeah.
this accident?
The testimony from my client, Spencer Middleton, and Mr. Beach, who's seen in the photograph attending to the plaintiff on the ground, that's him, that's Robert. Middleton and Beach both testify that the truck is stationary. Now, this testimony from the plaintiff that the truck was veering to the right, it's our position that it's not relevant to the disposition of this case. The plaintiff had an obligation to stop behind my client's vehicle, regardless of whether he believed he had enough space to pass or not. This is simply akin to lane splitting on a highway. It's not legal in New York. It's a violation of VTL 1123A for attempting to pass in a situation where it was clearly not legal to do so.
So
mean,
even
there
if
are-
we accept it, I'm sorry, go ahead.
I mean, there are situations where you might be able to pass on the right, but none of those exceptions applied in this case to these facts, correct?
That's absolutely correct. VTL 1123 provides for 3 scenarios where you could pass on the right. None of them apply here. There's specifically Section 3 of that statute provides for one-way roadways. Clearly, the standard there has not been met based on the facts here that are undisputed. Thank you.
Thank you. Yeah, okay. Do you have any reply there? Okay, you're gonna, yeah. People versus Ronaldo Peguero.
For Ronaldo Peguero, Claire Glass with the Legal Aid Society. Mr. Peguero left school at the age of 17 to go to work after his father became too sick to work himself, and he supported his family that way. And then he went on, similarly, to support his wife and children through working steadily since the age of 17. And this is just one of the reasons we now ask this court for any modest sentence reduction to allow Mr. Peguero to return to that family who remains by his side and has remained by his side from the day of his arraignment, appearing at every single court appearance to support their son, their husband, their brother, until the day he was sentenced.
So he he got 15 years, right?
Yes.
And he executed a waiver of appeal, which would normally prevent you from arguing to reduce his sentence. So why are you here?
Yeah, so normally a valid waiver of appeal would do just that, Your Honor, but there are a number of problems with the appeal waiver here. In particular, the written waiver form that Mr. Peguero executed here is one of those forms that this court has previously held unenforceable coming out of Bronx Supreme Court. So considering the fact that yes, Your Honor.
That's fair, but the oral waiver, which is what we really look at, the allocution, to make sure they hit all the right notes, there was no real issue with that. I mean, you can't, the written waiver is usually an added prophylactic to say, just in case the oral allocution fell short, we have a written waiver, particularly when you had the opportunity to review it with counsel, make sure counsel explained it to him, go through that in the allocution also, you discuss it with counsel, blah, 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 that's your signature and all the other stuff that takes place. So against that backdrop, the argument that the written waiver may have some issues in terms of its text doesn't really warrant rendering the waiver invalid, does it?
Well, it does in this case, Your Honor, for a couple of reasons. So putting aside the fact that this waiver has been flat out deemed unenforceable by this court in the past, we also need to look at the chronology of events during this court appearance. Mr. Peguero was asked to sign this legal document and deliver it to the court before the court's colloquy. So he had a conversation, about this document, signed it, gave it to the court, and at that point, a layperson, it's not the responsibility of the layperson under these circumstances to parse which delivery of, the right is correct. The fact that the court's colloquy directly contradicts multiple aspects of the written waiver renders it invalid here. And if I might, since my white light is on, if I can return to the merits. Looking back quickly at Mr. Peguero's family connections, I just want to note that this court has reduced individual sentences in the past for similar reasons in People v. Fernandez and People v. Easton.
Well, your client did face a mandatory life sentence, didn't he, on the top count, had he been convicted of that top count?
Had he been convicted, yes, but all of the parties saw fit to offer Mr. Peguero a different sentence, and I think that is...
I know, that's, I guess, what we're trying to figure out. Why is that sentence not a fair sentence?
Well, Your Honor, the parties all agreed Mr. Peguero should not be facing life. He deserved leniency.
He got a lot of leniency.
and-
He got 15 years as opposed to life, right?
our-
So why isn't that fair?
Well, it's the court's responsibility to...
No, I just want to know. You don't have to tell me what my responsibility is. I
Understood,
want to
Your
know why that bargain for sentence, which is way less than what he could have gotten, is unfair.
This is someone who is exceedingly unlikely to reoffend. Mr. Peguero, and this is actually another opportunity just to correct the record, Mr. Peguero had never been convicted of a violent offense at any point before. And in fact, the only prior felony conviction he had that just by a hair made him a predicate was when he was 21 years old, almost 10 years prior, and it was an E felony for criminal mischief related to graffiti. And this was an art student who, worked as a tattoo artist.
He did have 5 misdemeanor convictions, as well as that one felony conviction that you're talking about. And the trial court did have all of this in the reports that they took into consideration before working out this plea.
That's true, but it doesn't change Your Honor's ability to take another look at this. And the nature of this crime was completely different than anything Mr. Peguero had ever been accused of.
He shot someone in the head,
Of course. And this
right, and killed him.
This is not...
Took out a gun in the middle of the day, I had a beef with the guy, I took a gun out and shot him in the head. So yeah, that's quite different from his other...
Yes, and of course, Your Honor, this is an unexcusable act. This is a tragedy, and our requesting a reduced sentence does not, it's not our intention to diminish the seriousness, but rather to ask this court to look at the many reasons why Mr. Peguero is so unlikely to reoffend, that this stands in such stark contrast to everything in his history, that he worked consistently from the age of 17 to support his family, to be there for his children.
Okay, I've actually given you a lot more time. Okay, thank you.
Thank you, Your Honor.
Good afternoon. May it please the court. Larry Glasser for the respondent, people of the state of New York. In this case, as part of a very lenient negotiated disposition, first of all, the defendant validly waived his right to appeal. As Your Honor indicated, any discrepancy can be put aside by the fact that the court explicitly and expressly told the defendant he can file a notice of appeal within 30 days. And the defendant did so. This isn't a situation where he was misled and is now asking the court to accept an untimely appeal. He repeatedly, on the record, stated he consulted with counsel. He consulted with counsel before signing the appeal waiver, before deciding to plead guilty. He had no questions about the appeal waiver. He understood it was not automatic, but it was a separate and distinct right or set of rights he was being asked to give up in exchange for this disposition, which he wanted to obtain for reasonable reasons. So at the outset, I would submit to the court that there is a valid appeal waiver, which did expressly inform the defendant that it will include a claim that his sentence was excessive.
And did the court consider all the mitigating factors that are being discussed now?
It did, Your Honor. All of these factors were contained in the pre-sentence report. And although it's not clear from the record, there's no reason to think these weren't considered by the people in formulating this very lenient offer, where the defendant ended up with a disposition where he is guaranteed to be not only finished with his incarceratory sentence, but also finished with his post-release term at a time before he might have been eligible for parole if he had been convicted at trial. He faced up to 25 years to life. He might not have been eligible for parole until 25 years have passed. At a minimum, he'd be eligible for parole consideration after 15 years.
I was just wondering how you would respond to counsel's argument that this was so out of his nature, this particular act on this particular day. He went out, he bought a gun and shot the person, had nothing to do with all the other things in his life.
I think it's out of most people's nature, and the egregiousness of it is what justifies this sentence.
Wasn't, if I'm not mistaken, there was no immediate remorse from this heinous crime. My understanding, he fled, correct?
He fled, and
my understanding that he didn't initially admit the crime, but he actually argued that it might have been in self-defense.
yes.
And not only that, but during his interview with the Department of Probation, he claimed that he was being chased with a knife.
Yes, Your Honor. And I would add that it wasn't just an instant knee-jerk denial to the police. He first claimed self-defense, and then even after pleading guilty, he attempted to blame the victim. But factually, what he said here, which is not in dispute, is that he did have a beef with the defendant. He left, which he should have done, but instead of leaving it at that, he got a gun, he came back, he admitted pointing it at the defendant, he admitted wanting to scare the defendant, and he did more than that. He shot him 3 times in broad daylight in the middle of the afternoon in the lobby of a Bronx residential apartment building. So yes, this is extremely out of character, and that is why he was charged with murder and facing a life sentence, but in light of all the factors counsel pointed out, I mean, he is a convicted felon. I believe Your Honor said 5 misdemeanors. I think he actually had 6, if I'm not mistaken. He had juvenile delinquent and youthful offender adjudications. He's had violations of probation in the past. He had bench warranted in the past. He had violations of conditional discharges in the past. Nonetheless.
So he didn't have a history of complying.
Correct. He didn't have a history. Every time he had been shown leniency in the past, he abused that leniency, whether it was a violation of probation, violation of conditional discharge, and yet here he received the significant reduction from a life sentence to a determinate sentence, which on the advice of counsel, he reasonably chose to avail himself of.
Thank you.
Thank you all.
So first, I just want to respond by saying, to put this into context, those contexts where Mr. Peguero, where he was arrested in the past, this was trespass when he was a teenager, something that probably wouldn't even be prosecuted today. This is graffiti. This was an art student who was doing his art in a way we don't approve of. But it is not as if his past is this egregious thing that, the prosecution wants to paint it as. And this is all to say, not that this is not serious. It is absolutely serious.
But the real question is, isn't everything that you are suggesting to us, wasn't that all taken into account by him pleading to something that gave him a really good bargain for sentence? He never would have gotten 15 years if he went to trial, never. And it was pretty clear that he was going to get convicted. So why is, again, I have to ask you, why is it unfair? Why is the sentence excessive? It seems like a pretty reasonable sentence.
Well, we don't know what would have happened at trial, nor does that constrain this court's authority to look at the circumstances, even the identical circumstances that the trial court examined, and make a different determination. And here, this is someone whose exit from prison will be a soft landing to a loving family, to a resume with careers that he's likely to be able to pick up where he left off. This is someone who's going to do well when he's released, who has young children who need him. And those are the reasons we're asking for this. And just very briefly, You know, Mr. Peguero did express remorse, and actually the trial judge at sentencing acknowledged that he felt Mr. Peguero had been remorseful in this case, and that was after viewing the pre-sentence report where Mr. Peguero made some gesture towards, you know, an imperfect self-defense here. But, you know, that didn't affect the trial judge's assessment of Mr. Peguero's remorse. And he did admit to having the gun, to shooting the gun to police immediately, you know, once he was in custody.
Thank you. Corvus Capital versus Strand Hansen.
Good afternoon, Your Honors. May it please the court, Jerry Silver from Sullivan and Worcester for plaintiff appellant Corvus Capital. This case arises out of fraudulent and malicious conduct by the defendant respondent Strand Hansen in using a New York agent to tortiously interfere with a United States securities transaction.
There's no dispute that in the original agreement between Strand and Corvus Conduit, that UK is the venue.
Well, the key here, though, is that's a contract between Strand Hansen and Conduit, not Corvus. Corvus isn't a party to that, and I think that's
fair enough. Okay, so your whole case, in a sense, rises, at least being here, on the fact that a New York law firm, on behalf of a client, sends a letter to California advising the Murphy here that there's litigation in England. So what's being done so routinized and so commonplace and pretty typical of a commercial litigation firm, how does that rise to the level of being tortious interference?
No, I understand. I've been practicing in New York for a long time, and a lot of times clients say, hey, there's a transaction going on here, and I have a claim, and I want these people to know about the claim, so please send a letter, right? That happens all the time. And you know what I say to them? I say, look, you better make sure every fact you give me is 100% right, and you better be doing this for a real reason, not just for a revenge or to kill the deal. Because if you don't do that, make yourself
Well, they
wide
did
open
bring the
for a
litigation,
tortious interference.
right? They brought the litigation. So it wasn't the litigation was actually commenced in England, right?
Right, but the thing is...
Okay, let me ask you this. Let me start with this. Who are you saying was tortiously interfered with? What entity?
Oh, they tortiously interfered with the transaction.
No, there's no, you can't, the transaction is nothing. Who are you alleging the claim against?
They tortiously interfered with business relations.
Of whom and
the business
whom?
relations
Of
are
whom and whom?
Okay, Corvus, the two investors, which are Murphy Canyon and Nerland, and also Conduit. And
Is this because Nerland then changed the terms that they're claiming that they changed the terms of their investment? They wanted a larger return, and that's why they feel that there was a tortious interference.
Yes, that gives rise to the damages. Like if it wasn't for the statement that we claim is fraudulent and the malicious act in the Weil letter, that wouldn't have happened. The
So
deal
your
was set.
relationship was with Nerland. That's the relationship you're saying was interfered with because Nerland then made you put up more money, correct?
Nerland did have to put up more money, and I think where you're going is that they claim that they didn't know the name of Nerland.
No, what I'm saying is the letter wasn't sent to Nerland, was it?
No, but that doesn't matter respectfully under New York law. The whole point
I think
is that
it absolutely does matter. You and I can disagree with that. But if you want to tortiously interfere with someone, you have to actually do something with respect to that relationship. You're saying your claim is that you tortiously, the defendant tortiously interfered with my relationship with Nerland because after you sent that letter, Nerland made me put up $20 million more, correct? Is that not your claim?
No, my claim is that they knew that there was a pipe investor involved in the deal. They might not have known the name of the pipe investor.
But I was just going to say that pipe investor also had nothing to do with New York. They were from Guernsey. So, I mean, where is the connection to New York, which is kind of the issue here, right?
Yeah, of course. I mean, the connection to New York, it's in the statute itself. I mean, it's pretty clear under the statute, 302A2, that if somebody commits a tortious act through an agent in New York,
So you're saying sending a pre-litigation letter from an international law firm simply because the lawyer who did it was in New York is enough to confer jurisdiction on the New York courts where none of the parties reside here, none, not even the tortiously interfered with non-parties. The transactions didn't happen here, and the damage wasn't caused here, right?
under the statute,
I'm asking you.
no, I'm not saying that
Okay,
because
so?
because first of all,
Yes.
a single act is enough. This wasn't just a pre-litigation letter. There would be no, if they just said, hey, we have notice of a claim, we want to make you aware of it, that's not a claim. I wouldn't be here. But they made a fraudulent statement, and before they did it,
No,
they said
no,
they wanted to kill
but you're
the
saying in the pre-litigation letter, they made a fraudulent statement. Isn't that?
I don't call it a pre-litigation letter. I call it an interference letter because the
Okay.
whole point of it was
Fair
to
enough.
kill the
In
deal.
the letter that the law firm sent.
Yes.
The law firm, so you're saying simply because the lawyer has a desk in New York, even though nothing else has to do with New York, the claims have nothing to do with New York, the parties have nothing to do with New York, nothing else has to do with New York, you think that satisfies due process?
Yes, here, because it's because everybody knows why you choose Weil Gotshal to mess up a securities transaction in New York. They had English counsel. They could have gotten somebody in California to send the letter to the California. Everyone knows you choose somebody like a firm like Weil Gotshal because they're renowned in securities law in New York, which is the king of securities law, and they did it. So they purposely availed themselves to New York. And that's why you choose a firm like that to do this. And that's, okay, thank you.
Thank you.
Thank you for the extra time.
Counsel?
Good afternoon, and may it please the court, Michelle Sloss from the law firm of Binder and Schwartz on behalf of defendant respondent Strand Hansen.
So what do you say to to counsel's argument that the letter, because the lawyer who sent the letter had a desk in New York, that confers jurisdiction on the New York courts?
It absolutely does not. As Your Honor pointed out, all the relevant activity here was outside of New York. While a lawyer may have drafted a letter and sent it from New York, there is no case law. Corvus cites not a single case where personal jurisdiction was exercised over a defendant for tortious interference when no party was in New York, the alleged business relationship was not in New York, the harm was not in New York. And in fact, there's persuasive authority, the Orlando case that we cite from the Southern District just a couple years ago, where the Southern District clearly stated hiring an attorney to perform a task in New York that they could have performed anywhere in the world is not enough.
This lawyer could live in Connecticut, and though his letterhead says New York, could have written that letter from his or her home in Connecticut, and I guess that by a fortiori, then Connecticut would have
That's right,
personal
Your Honor.
jurisdiction.
And there actually isn't even an allegation in the complaint of where the lawyer was physically sitting. It was Weil's New York office, and we take that as true for the purpose of this appeal, but it is simply not enough under the statute, nor is it enough under due process principles.
And what about the amended complaint? Are there any New York entities in the amended complaint?
No, Your Honor. This case is about a UK company that entered into a contract with a Cayman company governed by English law. When my client believed that contract was going to be breached, it sent a letter to a company in California. Corvus's argument is that at some point after that letter, a Guernsey company changed its deal with Corvus, which is another Cayman company.
So the only tortious act that could possibly have happened in New York was the sending of this letter from Weil Gottschalk's stationary office.
Yes, that's the only alleged contact with New York or interaction with New York at all. There's simply no case law to support Corvus's arguments here. And finally, I would just like to address the amended complaint issue. Corvus argues that the trial court ignored or overlooked the amended complaint. Strand Hansen filed its motion to dismiss the original complaint, and then Corvus filed its amended complaint before submitting its opposition brief, which addressed the amended complaint. Strand Hansen's reply addressed the amended complaint, and oral argument before the trial court addressed the amended complaint. There is no basis to believe that the trial court did not consider the
Although the
sufficiency.
order doesn't make it clear. But anyway, we can consider the.
That's right. And my,
right?
my next point is that nothing in the amended complaint changes the
Changes any of
analysis.
the arguments.
I know this is a separate issue, or not really critical here, but based under FNC, nobody's here. It's really inconvenient to be here when everybody's in England, right?
That's absolutely correct. Again, the only connection to New York is Weil, and Weil has nothing to do with the activity that is allegedly tortious, the business relationship that was allegedly damaged.
Because the lawyer's not the party who's tortiously interfering, right?
That's right.
It's the defendant.
That's
the
right.
alleged defendant, or the defendant is alleged to have interfered. Okay, thank you.
Thank you.
Just quickly, one thing I want to note, there's only one party, one entity involved here, that's in England.
If you want your time, let me just reset the clock, okay?
Sorry about that, I got too excited.
I know, you were excited, I am too. It's a good argument.
Yes.
Go ahead.
Okay. Yeah, I mean, but I just want to address that point. There's only one entity in England, and that's Strand Hansen. Everybody else is elsewhere. So it's not like
Cayman
everybody's
Islands.
Entity
in
here
England.
in New York.
Well, but the point is, this is all based on 302A2. The actual literal statutory language says a tortious act by an agent in New York. And Weil's an agent. It was a single tortious act, and as alleged in the complaint, it happened in New York. So under
But the
letter of the
tortious
statute,
act is done by the defendant, not by the law firm.
right, a defendant using an agent. Weil's under the letter of the statute. There's
You're
jurisdiction.
saying that just writing the letter is the tortious act that the agent is doing? Or threatening to, or the act of threatening the litigation?
No, I'm saying that the act of writing a letter, if it contains a fraudulent misstatement that or tortiously interferes or does so maliciously, that's enough under the letter of the statute for there to be jurisdiction. And with regard,
Are there any cases that say that? Because
Yeah, I
I found a
cite-
couple
I
that
do,
go
I
the other
cite-
way. I found a couple of cases that say that's not enough, but I didn't find any that said that a letter from a lawyer, an international law firm that's on New York letterhead would be enough to confer jurisdiction.
I did find cases that say a single act by an agent is enough.
I know, but
yes,
in that case, it's like, I'm the agent, I'm doing the actual thing that is the basis of the tortious interference.
Right, we do cite cases
That's a
where people
different-
sent false cease and
Counsel?
desist letters,
Counsel?
and jurisdiction
Hold on
was
just a
found.
second. We have a question. Judge, go ahead.
Counsel, could you compare this, if you would, to Humphreys, a 1997 case where the court found that, we found that a letter informing a defendant's new employer of a lawsuit between the employer and the defendant, which advised that it would be held responsible for any damages, was not sufficient to sustain tortious interference.
I agree with that. That's exactly what I tried to say at the beginning of this, that if all you're doing is putting somebody on notice of a claim and everything you say there is true and you're not trying to act maliciously, then that's totally fine. I agree with the Humphreys case. But my point here is that they falsely stated that the agreement was terminated using that language, citing the language from the agreement to give rise to a fee. They shouldn't have said that. That's false.
Okay.
And they shouldn't have done it just for revenge.
Okay, thank you.
Thank you very much.
Thank you. Dougherty versus City of New York.
Good afternoon, Your Honors. If it may please the court, Jimmy Wagner for the appellant Dougherty. The lower court here made two primary incorrect rulings. The first incorrect ruling in dismissing this complaint, this discrimination complaint, was converting this discrimination complaint into a special proceeding under Article 78. At the lower court, my opposing counsel put that argument before the counsel.
But they've conceded that basically on appeal.
I just want to make sure that
yes, we agree.
we all agree
We all
that
agree.
the lower
This
court had no authority to do that conversion.
Yes, so let's go on to the real issue.
Let's go on to the real issue here. This case is actually slightly different than some of the other cases I've argued before you, because the lower court judge here said there was no adverse action. That statement of law was wrong for two reasons. Because under New York City human rights law, we only need a less well treatment. I don't need an adverse action. But going under New York State human rights law, to state as a matter of law that forcing your employee to put something in their body that violates their
Have we
religious
not
belief-
looked at this more than one time? And haven't, in fact, you've argued this more than one time,
I have,
right?
I
And we
have, Judge Scarpello.
consistently said that, two things. We have consistently said that the dialogue issue was sufficiently dealt with. We said that in Marstella, right? That was enough. And I doubt we're going to reverse ourselves on that. And the first thing is, what else are you arguing about? The plaintiffs failed to accommodate.
So, correct.
Okay.
I don't believe this court needs to reverse Marstella at all. Marstella is an Article 78 special proceeding where the court gave deference to an agency on a decision. This is a discrimination.
No, but we also dealt with the question of whether there was a meaningful dialogue in Marstella. I think I was on that panel. So, okay, let's assume that issue, put that issue aside.
And again, the failure to engage in cooperative dialogue is only one cause of action under this complaint.
The first one is failure to accommodate. That's what I'd like you to focus on.
Okay, under failure to accommodate, this plaintiff alleges in the complaint there was no cooperative dialogue of any kind at all.
But
He didn't
that's a
receive-
different thing. Let's start with how did he plead enough to show that he should have been accommodated?
So the lower court found he pled enough. To plead a discrimination claim, you need to first find that you're a protected class. You need to find that you're a protected class, that there was an adverse action, that you can continue to do your job,
Is it enough?
and that other people were treated differently.
Is it enough to say that I'm Catholic and I'm made in God's image, so I object to a COVID vaccine?
Well, absolutely, that is more than enough, but the lower court agrees with that statement. The lower court found him to be a protected individual. The lower court here denies this case because it states as a matter of law, forcing someone to be vaccinated is not an adverse action. We do not allow people to remove we give people accommodations for their wigs, for their dietary needs, for everything. This Catholic in New York State has a long history of discrimination against Catholics. This Catholic stated, I am made in the image of God. That is no different than saying Jesus Christ is the Word become flesh. Catholicism has a history of brief, to-the-point statements that have a theological depth that judges should not be trying to interpret. And what the judge here...
Counsel,
Yes.
is there any writing or a pronouncement from either the Vatican or the Cardinal of the Archdiocese of New York indicating that the COVID vaccine was violative of the faith?
Judge, I appreciate that question. As a practicing Catholic, I can tell you Pope means servants of the servants of God.
No. The question
My client
was, counsel.
Counsel, we're talking one-on-one here.
I understand.
Was there any writing from the Council of Bishops or from the Archdiocese or the Vatican instructing Catholics not to take the vaccine?
As the U.S. Court of... In this record, absolutely not. That's number one. So let's stick with this record. But if we're going to go outside the record...
No, we're
the
not
US
going
Court-
outside the record, counsel.
I shouldn't be asked
And-
questions outside the record.
All right, thank you. Counsel?
Good afternoon. May it please the court, Hannah Sorokin for respondents. Your Honors, as Your Honors already mentioned, this complaint fails because the allegation about what was conveyed to NYPD is just, as Your Honors mentioned, that he is Catholic, created in God's image.
Well, let me ask you a couple of things. Once you agree, you agree that this didn't have to be brought in an Article 78 proceeding. I think we all agree on that, right? That this is a perfectly valid plenary complaint.
Correct.
Right? But what I think the argument was, and what I'm asking you about, is whether it is sufficient to say that I wasn't accommodated because I don't think I should have, my religious belief, Catholicism, it, says that I can't take this vaccine, right? So, and the question, so my question to you was Mr. Dougherty given the opportunity to apply for a religious exemption?
He was given that opportunity to apply for
As was anybody else who had a religious objection, right?
He does not allege that he was treated any differently from anyone else in this.
Right. So anyone who had a religious objection got to apply for an accommodation.
Correct.
And did he apply for one?
Yes.
And it was denied.
Correct.
So, as were many others.
Correct.
Okay. So then, I guess we're wondering, where's the disparate treatment?
There is no disparate treatment here. He does not allege that the process was any different for.
I'm trying, maybe, because I'm not that familiar with Catholic ideology in a sense, but don't you have to explain how the vaccine itself violates a tenet of his faith? Simply because I believe we're all made in the image of God respectfully. It's not limited to Catholics. But putting that aside, was there anything on this record outside of what I heard your friend say about, I'm created in the image of God, therefore I get an exemption? Is that enough?
It's not. It's squarely not.
Was there any, and I had to understand from this record, was there any discussion about how the vaccine itself violated a certain belief specifically, or for example, the use of stem cells from fetuses where, I mean, you can make was any of that made in this record?
No, the only allegation of what the plaintiff here said to NYPD in seeking accommodation was that he's Catholic and believes he's creating God's image. He did not plead that bridge between any Catholic belief, any Catholic tenet, and a conflict with the vaccination. That, in the complaint, that allegation, I believe it's page 25, doesn't even mention vaccination. When he's talking about what he said when requesting reasonable accommodation, he doesn't mention vaccination at all. So the complaint fails because he did not.
And it's clear, according to the requirement to have a cooperative dialogue, that your department, through notices and forms and the whole protocols, that we've held, whether to a practicing Catholic or anyone else that has some kind of objection. That's the process that constitutes a dialogue that we've held as appropriate.
Correct. And I'll also note, even beyond Marsteller, I think in Article 78 is still addressing the same issue of whether it violates the law, but also in the later Goolsby case, this court, in a plenary action, affirmed or confirmed the Marsteller, the applicability of the Marsteller rule. So the process afforded here for reasonable accommodation, this court has clearly held it was sufficient.
Thank you.
Thank you.
Counsel?
I think, Justice Shulman, you're falling into the trap that this court continually falls into. This court is not supposed to engage and get into the thickets of theological weeds. New York City human rights law is very clear. Once the accommodation request is made, there needs to be an understanding of what that accommodation is. I've listened.
It just seems to me that the cases have said that there has to be something more alleged than what your client alleged in this case.
Cases from what court? Because the U.S. Supreme Court says absolutely not. I'll tell you, this court in Hoskins, when it's dealing with a disability, this court turns around and says, nothing's off the table. It has to be individualized. It has to be personalized. So is this court making it as a matter of law that we're going to give people with disabilities a different standard of cooperative dialogue than we're going to give to people of religious accommodation requests? Article 78, I'm not asking this court to overrule Marsteller. I'm saying on this individual basis, this individual put in his pleadings, there was no cooperative dialogue at all, whether the Marstella cooperative dialogue or any other cooperative dialogue. So therefore, at this pleading stage, at the 3211 stage, this court was obligated, the lower court was obligated to take that statement as true. We can get to summary judgment. The city can show that they did engage in this permitted exception by Marstella, and then you deny my case at summary judgment. This is at a 3211 stage. There's been no discovery whatsoever. You're requiring me to prove my case, not just plead it, and that's highly inappropriate. The only mandate that actually exists in this case is the mandate from city council that I'm supposed to get a liberal treatment of these pleadings. The COVID mandate was an executive branch order. The city council has mandated that this court system give us 100% liberal pleadings. I thank you.
Thank you. Federal National Mortgage versus Monegro.
Good afternoon, Your Honor. May it please the court, Christopher Volante, Rosenberg, Fortuna, and Laitman for the appellant in this case. With my limited time, I think what I really just need to focus on is the fact that here this judgment of foreclosure needs to be vacated because it directed the sale of a property of an entity that exclusively owned this property but was never made a party.
Are you, well, we know that, but are you aware that this court has already weighed in on the re-foreclosure appeal?
I am aware of that.
We saw that
is
the
my case
decision
as well,
came,
so I'm
that it came out today.
I am aware of that, Your Honor.
And that clearly undercuts your whole claim that, just breathe, that clearly undercuts your whole claim that in the foreclosure action, that there was willful neglect and fraud.
That is true as far as that.
And that you lack standing.
That I lack standing? I don't think, I don't.
In the earlier,
I don't believe the decision this morning says I lack standing. I think it said that the plaintiff there did not lack standing to bring a re-foreclosure. However, I would also say that I don't think that decision is determinative here because that decision recognizes the fact that this judgment was void as against my client. That's the first thing it recognizes.
And that's why we had re-foreclosure, where you had a full and fair opportunity and due process and all the other bells and whistles that gave you an opportunity to establish that you are the owner of this apartment as a result of the condominium board's foreclosure, correct?
The only thing I would respond to that is that it is not the same opportunity. Re-foreclosure has a totally different standards, not just for myself, and cuts off the ability of a would-be, which should have been a defendant in the foreclosure, ability to raise numerous defenses, including, I think most notably, the statute of limitations, which is basically done away with in re-foreclosure and strict foreclosure.
Right.
And also gives a plaintiff a completely different burden. Proving willful neglect or lack of willful neglect and lack of fraud is not the same thing as a defendant who's named rightfully as they should in a foreclosure action and as a matter of right can assert not only statute of limitations, notice defenses, prove whether prima facie the plaintiff proved its defenses or, its burdens or not. All of that is wiped away where a plaintiff in this kind of context gets to walk opposition free to a judgment and then use that to start another case against me finally. It just invites...
You've gone a lot over.
I appreciate that, Your
And
Honor.
you're not arguing against anyone, so.
Well,
I read your
having a
brief.
discourse with the court. That's the way I see it.
read your brief.
I
Thank you.
I appreciate that. Thank you very much, Judge Scarpello.
Milne Travel Agency versus Altour, Delaware.
Good afternoon.
Good afternoon.
May it please the court, Cameron Matheson on behalf of the appellant, Scott Mill. The motion court in this case dismissed Mr. Milne's fraud claim, finding as a matter of law that Mr. Milne should have known facts that the defendants to this day deny are true.
Not that he should have, he could have. He obviously says he doesn't, but he could have. It's not, you don't have to know them, but you have to have the opportunity and should have found them out.
Well, what he did is he learned that there had been a transaction involving a predecessor of defendant Internova, that they had purchased an Altor entity, which he assumed
In
was
December 2017, he finds it out, right?
He sent an email.
Hires a lawyer.
Hmm?
He hires a lawyer in December 2017 who says, I think this triggers that provision, and I think it doesn't pass the smell test.
Or the straight face test.
The straight face test.
Right, the straight face test, similar test.
Correct. So he assumed that Altor Altor International is the Altor entity that would need to be purchased to trigger his tag-along right. He heard there had been a purchase of Altor. He assumed it was Altor International. Sent an email saying he wanted to get the terms of that transaction so he could determine whether or not to avail himself of his tag-along right. What he was told in response is Altor International was not the Altor entity that was purchased. It was a different Altor
And
entity.
that was the end of his inquiry?
Well,
Given that he thought that there was, that it didn't pass the test and he had inquiry, he was concerned, he just bought that and that was it, walked away for 6
Well,
years?
actually, no, that was what he was told before he sent the email, because in the email he says, well, I don't think it passes the straight-face test. So he had clearly already
And he
been
hires a lawyer, and the lawyer doesn't get any documents. They don't look at the transaction. They don't ask for anything from the other side.
Well, actually, whether or not any of that happened is not in the record. We don't know what the investigation was.
Well, you would have to plead it to avail yourself of the discovery rule, wouldn't you? You'd have to plead that you did something, because we all agree the 6 years has passed.
Correct.
The only thing that you can do to keep yourself within the statute of limitations is argue the 2-year discovery rule. And you'd have to plead facts to show that you didn't know and you couldn't have known.
So he sent the email asking, and the response back was to tell him that, in fact, no. Again, what they're
And
still
then
saying,
he hires a lawyer.
he
What
had.
does the lawyer do?
Well, the lawyer was to evaluate the terms of the deal to make the determination of
So
whether or not it was.
He had all the documents.
He didn't
Did he
have the
not?
documents.
So how could the lawyer determine what the deal was without the documents?
So that was what the request was. So
Right,
the
so what
lawyer
happened?
drafted an email.
Those emails are not part of the record. The response is not part of the, we don't have those responsive emails.
The only email that's been put in was there was an email
And
drafted.
it doesn't, I'll call you later, I'll
Mr.
catch you
Milne-
in the morning, yeah.
Yeah, Mr. Milne's lawyer said, here's an email you could send them to ask them for the information about the deal. And he then forwards that email where he says, no, what you told me that this wasn't Altor International doesn't pass the straight face test. That
That's
is
all
what
we
the
have.
defendants.
We don't have anything in writing saying it was a different entity.
Well, he said in Mr. Milne's email to the CFO, he says that I infer from that email that he has previously been told that it was a different entity, because he says, you telling me it's a different entity doesn't pass the straight face test.
And then
After
he just
sends-
drops it.
He's then told again, well, what's alleged is after he sends the email, he's told again, it was not Altor.
And then he just drops it.
Well, what-
Doesn't get the transaction documents, doesn't look at the transaction, doesn't make his own, doesn't do his own review at that time in 2017, doesn't do any of that. He's got a lawyer. He himself thinks it doesn't pass the straight face test, but he doesn't do any investigation.
And just keeps on working with them.
What he was told is that, so Altor International was owned by Alexander Kemla. He was told, Mr. Kemla is still running the company, he didn't sell it, nothing is going to change. And in fact, that is what happened. He continued to work with so there were the 2 joint venture partners. And under the agreement, he was running, Mr. Milne was running the company, but his interface for the other joint venture partner was Mr. Kemla. He was told, he didn't sell his company, you will still deal with him every day. So his investigation was the fact that that was in fact exactly what happened. He continued to work every day. That was the person on behalf of Interno.
So based on that, he figured, okay, everything was right. Now I'm okay with it, and now it passes the straight face test.
Correct. That's exactly what happened. His investigation was what they told him would happen is what happened.
Okay, thank you. Counsel?
Good afternoon, Your Honors. Joshua Schlanger of Shepherd, Mullen, Richter, and Hampton for defendants' respondents. Your Honors.
So what's the matter with that picture that he's painted
So
here?
the problem with the picture is that they pleaded a certain narrative. The narrative was, oh, I heard about something, and I'm inquiring about the facts. And then there were misrepresentations about the actual terms of the deal, as well as some facts which really have nothing to do with whether or not the entity was bought. And we're here on a CPLR 3211A1 motion to dismiss based upon documentary evidence, and the undisputed, unrebutted, completely authentic documentary evidence, December 11th, 2017 emails, refute that narrative. They show that plaintiff's counsel told plaintiff himself, I understand that on or about August 31st, there occurred a transaction within the meaning of the above quoted paragraph, and then asks for valuation methodology. This is at pages 116 to 117 of the record. And then Mr. Milne forwards that email to the then CFO of Altor, Delaware, the successor to
Mr. Snyder?
Sherman Snyder, exactly. And then Mr. Milne acknowledges that he's already heard the alleged misrepresentation that is the basis for the fraud claim, namely that it was a different Altor entity that was purchased. And as the court has already acknowledged, he says, I don't think the notion that deal, that's what it says, that deal, was with different Altor than Milne deal, therefore drag and tag are not activated, really passes straight face test. If I understood you correctly, and subsequent argument will be that even if drag/tag applied, valuation of JV isn't same formula as Altor's. Well, let's just say, I hope I misunderstood. I think it would be good to expeditiously resolve this and move on to growing biz. So what the undisputed, unrebutted documentary evidence shows is that Mr. Milne was aware of all of the facts that he would have needed to make that decision at the time. He slumbered on his rights, opted to continue the business, and did not timely bring his fraud claim. So the 6-year statute of limitations passed in December of 2023.
So his claim that you told him that things would continue on, the same person would continue running them, wasn't enough so he could sort of say, okay, that's fine, I believe you, and now we're all finished.
Exactly, and as Supreme Court noted in the written decision, those allegations make no difference to whether or not the entity was bought. Just because the same personnel are going to continue running the company in an acquisition doesn't tell you whether the entity has been sold or not, or whether it's been a different entity. And these facts alone distinguish the cases that the plaintiffs rely upon, both on the statute of limitations issue and on the justifiable reliance issue. So on statute of limitations, they cite the Saphir International case from this court from 2006 and the CSAM Capital case from this court from 2009. And both cases say the same thing. If the plaintiff, acting with reasonable diligence, I'm quoting from Saphir now, could have discovered an alleged fraud, then the plaintiff may not shut his eyes to facts which call for investigation. And now the outcome in those cases was different. The courts held that there was inquiry, but then there was a cover-up. That's not the case here. This was not mere inquiry. This was, I've heard your representation. I think it's completely incorrect, and I am pressing my tag-along rights, and then inexplicably, it was dropped. So this case is not at all the same as those cases. And for the same reasons.
So I guess what you're arguing is it's not justifiable reliance if you're told, oh, nothing's going to change, even though you think the transaction smells bad and would trigger your rights. If we tell you it's all good, that's not sufficient justifiable reliance.
Exactly, Your Honor. So
Okay.
you'd have to get past the statute of limitations issue, but even if you reach justifiable reliance.
Well, it's part of the statute of limitations, right? You have to show both things, that it wasn't justifiable to rely on whatever you told them in response to his questions. Okay,
Exactly.
thank you.
Thank you, Your Honors.
Mr. Milne didn't just inexplicably drop it. What opposing counsel is focusing on is the email and not so much on what happened afterwards.
Yeah, but that's not in the record. That's the problem.
It's alleged, this is a motion to dismiss, it is alleged in the complaint.
What's alleged?
What's alleged in the complaint is that after he sent the email, what he was told in response
And your argument is what he was told in response, he justifiably relied on?
Correct.
Even though he wrote a letter that says this doesn't pass the straight face test?
Correct.
Okay,
That's the basis.
okay.
So-
Anything else you want to, anybody have any other questions? Thank you.
Thank you.
Jackson versus Laconia Nursing Home.
May it please the court, I'm Annette Hasapidas, representing the plaintiff in this case. Respectfully, the court erred in granting summary judgment on the defendants in this case never made out a prima facie case, and the plaintiff raised questions of fact in opposition, assuming that the defendants met their burden of proof. In a special employer case, the standard of proof for a defendant is very high. Under Bellamy,
I'm sorry, but in this case, we have someone with personal knowledge, namely Manny Goldman, who's the director of Laconia, who basically says, we, notwithstanding that Ms. Jackson came from a service and that the service may have taken care of some of the compensation, et cetera, but the focus really is control of the work. And on this record, Mr. Goldman made it very clear the protocols for the training of the nurses, for the supervision of the nurses, the hierarchy. I know you know the record, and I'm keeping it really simple. That is a prima facie case.
well, Your Honor, respectfully, Mr. Goldman didn't have personal knowledge. Mr. Goldman testified that his responsibilities were to purchase supplies and were to forward the payroll hours to town, and that's at pages 96 to 101 of the record. He admitted and testified that issues with respect to the licensing of the nurses was something that, and the scheduling of the nurses and the staffing with town was always handled by Paula Sammy, and that's at page 226 to 227. And Ms. Guerrero also lacked personal knowledge concerning the scheduling of the nurses. At pages 348 to 53, Ms. Guerrero said that Paula handled scheduling. Mr. Goldman had no personal knowledge concerning the training, the supervision, or the licensing of the nurses, and he admitted as much. Furthermore, under the law, the defendant's evidence raised a conflict. Under Bellamy, they have to prove a clear demonstration of ceding complete and exclusive daily control and the assumption of that control by the putative employer. They never met that standard. They submitted the contract, and at page 300, the contract only authorizes Laconia to request certain classifications of employees for the number
So
of
let's
shifts.
start with, who disciplines the employees? Laconia.
And
Who orders them to come in? Laconia.
No.
Who?
Ron, they do
Laconia
not.
says, the Laconia representative testified that if they didn't like an LPN or the person.
Or
right,
yes.
That they would say to town, don't send that person again.
That's different, Your
right?
Honor, than scheduling.
Is that correct?
That is with
So
respect
we
to
have
termination.
discipline, we have hours, we have
do not have-
training.
We do not have
Who
hours,
trained?
and we do not have training. We do not, and we have a conflict there because they proffered plaintiff's deposition testimony also. I mean,
Well, the contract says that Laconia is training, right?
the contract also says that, it doesn't say that only training.
I'll read
Look, the
it. I will read what the contract says about it. Okay. The personnel has to be subject to and abide by all applicable policies and procedures of the facility, right? And then,
Your Honor.
Laconia retains professional and administrative responsibility for services rendered, and everybody, and all the people, essentially all towns did was like a ADP. They were like ADP.
That's incorrect. Under the contract at page 300, all Laconia could do was request certain classifications of staff for certain shifts on certain days. Town assigned the staff. Plaintiff testified that she never spoke with Laconia, that her schedule was fixed by town.
No, what she said was, I called town and they said to me, call Laconia. That's what she testified to, right? If she had a problem, she said, I called town and town said, call Laconia.
And
is that not what she said?
no, that is not what she said. First, she said at page 631 to 632, she said she worked unsupervised, that an RN from Laconia was supposed to be in the building, but they were never there, so she worked independently. At page 661 to 62, which is the language that the court...
Plaintiff testified that she would contact an RN by calling town and say, I need some assistance. And town would tell me to go call Laconia, because you can't be calling us, because they have to be doing their job. That's what she testified to. 633, 634. We're both looking at the same testimony, right?
Didn't Laconia control?
No. She said, right, but she said that they were never, and then she goes on at page 633 to 634, there was someone there, but they were never there.
No, but
They were supposed-
that's a personnel issue. That's not a who controlled her daily job responsibilities, who controlled her training, who controlled whether or not the RN was actually on the floor is not relevant to whether she was a special employee.
They have to show exclusive daily control. My client testified, and they submitted her testimony at page 630 to 631, that town provided her with all of her training and her supervision, that she wore a town staffing agency name tag. She testified at 662 to 663. Laconia provided no training, no supervision, never gave her paperwork. They never produced a personnel file in this case. They had
Didn't she
nothing.
sign off on some training? Isn't there a sign off on some training that plaintiff did?
That was like it was a form. It was supposed to be representative of what she was given, but they never located the personnel file, and that's at page, well, it's later in the record,
And didn't they-
1069.
Didn't the nursing home control the shift times, and if they were unhappy with her, they would control whether she would come back or not?
They could ask that someone not be permitted to return, but under the contract, they could not ask for a specific employee. Town decided who filled the shifts. That was plaintiff's testimony, and that was the contract. And the point here is that to make out a prima facie case, they have to show, again, clear and exclusive daily control.
Who furnished the equipment that your client worked with?
There was no testimony in that regard.
I think the contract says right? The contract says Laconia, right? Who supplied the medication?
Laconia.
Who supplied all the carts and everything else that she used every day?
But I think we have
Laconia,
to flip
correct?
the analysis here. It is not just about whether there is evidence of some involvement by Laconia, but whether it is clear, exclusive, and daily. And in Bellamy, this court said that only when there are undisputed critical facts can you determine the special employee issue as a matter of law. My client at least raised a question of fact with the evidence in this record, with the terms of the contract that conflicted with Mr. Goldman's testimony. Mr. Goldman lacked personal knowledge. So at the very least, we were entitled to a trial because the evidence was not clear.
If town, as you claim, is in control, my understanding of the record is that town did not determine how much to pay based on the hours clocked overtime or holiday work. It came from Laconia, correct? That's page 112 of the record.
Yes.
Okay,
but
just bear with me.
Yes.
That means someone at the nursing home is controlling the shifts, the hours worked, and doing all the calculation, which in turn was turned over so town can pay your client, correct?
Yes.
That means that they had supervision and control to determine how they were working, when they were working, et cetera.
No, it
That's
did
pretty
not-
clear.
It does not constitute supervision of what my client did on the 5th floor of a nursing home during her shift. It just means
She admitted that the RN was her supervisor, right? If the RN was there or not is not the issue. The question is, who is her supervisor?
And
when she said the RN isn't there, she testified. And when I called, one moment,
sorry,
I
Your
promise
Honor.
I'll give you the chance to respond. When she called and said, my RN isn't here, she testified. Town said, go find her. We can't be doing this. And that's what your client said.
yes, but she also testified that the RN was never there, and so she worked independently. That was her word at her deposition. They were never there to supervise her.
May it please the court, Nicholas Calabria with Amity Demirs McManus for Laconia. Clearly in this case, as the court has pointed out, there is ample evidence submitted on this record.
Well, counsel, what do you say to your adversary's argument that no one supervised Ms. Jackson? That she testified that she wasn't supervised by anybody?
Besides being incredible as a matter of law, that a nursing staff, we're talking about 40 patients on a floor with dementia, that no RN was involved in their care. It's incredible.
Well, is it?
I would
Well,
point
the
out-
contract requires the RN to, not the staffing agency. The contract requires Laconia to supervise her, correct?
Correct.
And Laconia sets her hours.
Correct.
Laconia supposedly trains her, but she says that that never happened, although she signed a document that said it did,
That did.
right?
That's the orientation that was it was actually years before, because she had been working for a number of years at Laconia and then took time off and came back. This is the nature of the business.
Did she also get training through town?
I have
Did
no
they do any
idea.
training?
That's what, I mean, that's what she said. I have no idea.
Did she testify to that?
She said that she was trained. I mean,
Does
town had to supply an LPN, so they had to know that she was an LPN. I mean, I'm sure they checked her credentials. They
Well, I'm
weren't
sure
just
about
sending
that.
people off the street. Again,
Does Tao surrender control over their employees when they send them to a nursing home?
undoubtedly, they set the hours. They set if you look at the contract, it clearly says that the exact number of personnel classifications and hours shall be determined by the facility. It says that the agency further agrees to require the personnel to be subject to and abide by all applicable policies, procedures in the facility. We produced the policies.
Well, how about counsel's argument that Laconia didn't have the right to choose which employee came to the nursing home?
They would make a call.
I guess they had the reverse, though.
They would make
could
a
tell
call.
her,
We said-
don't send that person.
Yeah, we need an LPN.
Certain number of LPNs, not Jane,
Right.
the best LPN.
We need an LPN on the 5th floor because the LPN is out on maternity leave. Could you supply someone? This is the shift they're going to do. This is their responsibilities. It's listed, page 1087 in the record. The responsibilities, who they're supervised, what their qualifications have to be, and what their special demands were. They had, observe the condition of all residents daily and update the CNAs and RN daily of the patient's condition.
Counsel, on this record, and for summary judgment, on this record, was there anything from your friend that counters testimony that town did not supervise their people at Laconia? Any?
No, there wasn't.
But there was testimony at page 172 of the record that Laconia directly supervised
clearly.
staff,
Although
correct?
that's not right, because she testified that no one supervised her.
And again, when she was questioned if there was a problem, town told her to contact the RN. I mean, if one of the patients was sick and needed more care than an LPN could provide, she'd have to go to the RN and say that we have a patient that's having a problem here.
And town would not resolve that.
Counsel?
I think,
That's me up here.
Oh, I'm sorry.
It's
I know.
okay. It's okay. So, here the plaintiff is a licensed, practical nurse. And, am I correct in saying that she acknowledged that she was trained by Laconia on 6 topics? Do we have information as to whether those were 6 topics that pertain to her licensure as as an LPN?
I believe she had her license, so she was being trained to follow the policies and procedures of the facility. She wasn't just thrown
You
out there
don't
and say,
know.
do whatever you want. She
No,
had to
you say
follow
you believe.
procedures.
Counsel, do you know? Do you know what the training topics were?
No, I don't know what the 6 training topics were. I know she signed off that she had the orientation and that,
by Laconia.
yes. And again, I don't know
Thank you.
where this hearsay comes from. We have the director of the nursing home, Mr. Goldman, with 30 years' experience, telling us how the nursing home is run. We have the director of nursing.
Understood. Thank you. Counsel, you have 2 minutes.
Your Honor. Well, no one from Laconia ever testified to counter what the plaintiff testified to. Counsel's statements are, counsel's making assumptions here. Page 662 of the record, my client says, Laconia didn't want me to. She said, as soon as there is an issue, I could not go to Laconia. So it was clear I have to talk to town, whatever the situation is, and if they have a problem, they speak to town and speak to me. The court construed that as Laconia exercising control. All that established was that my client was prohibited from reaching out to Laconia, as far as she was concerned, and that sometimes Laconia may have said something in response, or it might have just been a reporting function if there was a problem. And at page 632, again, she says, there was someone assigned to be there. I'm not sure if it was Laconia or town, but she was never there. So,
Well, they said that there were probably only 1 or 2 RNs in the building, and they were often wandering around, but that the RNs ultimately had to report to someone higher up, Ms. Guerrero, who I guess had some more supervisory position.
That's right, Your Honor. And at 633, she says we were more or less working independent. At a minimum, my client's testimony raised a question of fact, particularly since it wasn't rebutted. Now, they've talked about Mr. Goldman and scheduling, and somebody could make a phone call. Mr. Goldman said that people would make a phone call, but he said the person that did that was Paula Sammy. Paula Sammy never testified. Paula Sammy never proffered an affidavit in reply to refute anything that my client said with respect to her contact with Laconia or lack of it and supervision. Thank you.
Thank you. People versus Lucas Almonte.
Good afternoon, Isabel Patkowski on behalf of the Legal Aid Society for Mr. Almonte. After the explosive revelation that the jury thought they understood untranslated Spanish dialogue going directly to Mr. Almonte's guilt, the court failed to tell the jury to disregard their own translations. And even though Mr. Almonte's defense was justification and a reasonable view of the evidence supported it, the court refused to instruct on self-defense. On either ground, Mr. Almonte must receive a new trial.
Maybe I'm missing something, but wasn't there some point where the judge was willing to give a full justification defense, and your client's co-defendant's attorney said, no, I'm good with whatever has taken place, and of course, your client's attorney at trial didn't say anything. So that, in a sense, when you're given a full and fair opportunity to get something that you're claiming was a problem here, then there was a clear waiver of that issue.
There wasn't, Your Honor, and this is why. Because at that point, the circumstances had already changed. Counsel had already had to give their closing, believing there would be no self-defense instruction. The jury had already begun deliberating. So there was no way for counsel to get what counsel had originally asked for, which was a self-defense instruction at the appropriate time of the trial. And therefore, counsel's failure to make a new request for a self-defense instruction at a different point in the trial in no way waives that earlier request. I would also point out that arguably
Hold up, didn't this come sort of in response to a note from the jury that they were, it seems like they were considering, they asked a question about self-defense, and it seemed as though that they were considering it, so then the judge brought the lawyers in and said, maybe I need to charge that since they're considering, and that was that whole discussion that went on at that time?
That's not exactly what happened. I think a fair reading of the record is that the judge was becoming frustrated with the prosecutor. The judge gave the answer to the jury, yes, you can consider it. Everyone said, okay, that's fine. The prosecutor then came back and said, actually, I think you need to tell the jury they can't consider it. And the judge said, no, I'm not telling them that. Look, do you want me to read the whole thing? I'll read the whole thing. And is saying it in a way that I think is arguably more expressing.
No, you can't tell anything about how the judge said it. We're all reading the same transcript, so don't put anything on it. The judge said, do you want me to read it?
To the
And defense counsel said no for co-defendant, and your client's counsel said nothing.
My client's counsel said nothing. And
Could have said right there and then, yes, judge, because he lost that before. This would have been the perfect opportunity for him to say yes.
It wouldn't have been the perfect opportunity because defense counsel's closing was over. You're supposed to know what instructions are going to be given before you make the closing.
Well, that is true. Right.
And so at this point, I don't know what counsel thought. Counsel may have thought, actually, at this point, it's going to do more harm than good.
Okay. But how is it preserved? I mean, I think that I keep hearing from my colleagues the question of, was this preserved? And I'm not sure that I'm getting the answer.
It was preserved because counsel asked for a self-defense instruction at the appropriate time during the charge conference, and the court denied it. And under the criminal procedure law, that's straightforward preservation. You ask for something, the court doesn't give it. It's
Okay, so if we saw the video, which we all did, and we agreed that there was no possibility that there's a viable justification charge, then you would agree that that issue is gone.
That's correct.
Okay, so then let's move on to the Spanish interpreter.
Yes, if I may just say one point to that, which is just to remind Your Honors, as you know, that the jury's note is an indication that at least some people on the jury did think there was a reasonable view of the evidence, even if, Your Honors may not. But yes, moving to the jury note.
Well, but the judge ruled that there wasn't a reasonable view of the evidence that would support that defense, and that's what we have to see on appeal, right?
Yes.
Whether that decision was proper.
That's correct,
Okay.
yes.
And she saw the video, right?
I'm sorry?
She saw the video.
She did.
Okay, so let's move on to the translator.
Sure. Moving on to the jury note. As Your Honors are aware, this was the very last note. The jury had already asked 7 questions across 5 notes, and this note really blew open the trial. The jury says there are Spanish-speaking jurors that we think we can understand Mr. Almonte say in Spanish something about hitting with a bottle. This is at a point in the trial where the prosecutor has never proven what's in the bag, and the jury has clearly been struggling with intent, as indicated by the fact that they've sent questions about it already. And everyone here, and this is what I really want to emphasize, everyone agreed what the court was supposed to do. There was no debate between the parties. Both defense counsel and the prosecutor all say the jury has to be told to disregard. And in fact, that's also what the CJI model jury instructions say, that a juror, even who speaks a language, may rely only, exclusively on what the interpreter says. But the court simply didn't do that. The court told the jury, you have to consider what's in evidence. It didn't ever actually tell the jury, your translations are not in evidence, and immediately the jury returns a guilty verdict after this exchange.
That's not what the court said. The court says you have to decide this case on the evidence. The term was not translated, and I cannot give you a translation now. That's what the judge said, and that was proper.
And that was, I'm sorry?
That was proper. It wasn't translated, and she wasn't going to go back and give a translation now, correct?
Respectfully, it's not proper, because all the jury knows at this point is that the video is in evidence. They've been told they can consider what's in evidence, and the court has never said you cannot use your own translations. That's all the court had to add, and it didn't add that.
Okay, thank you.
Good afternoon, and may it please the court. Assistant District Attorney David Crowley for the people. I'll start with the justification charge. I think the court has it correct. This judge was very open-minded about reconsidering the self-defense charge in light of a jury note. And I think contrary to my friend, that jury note was prompted because defense did argue that this was a self-defense case.
But isn't the defense of isn't the charge of self-defense not appropriate when the evidence shows that the defendant was the initial instigator of the incident, and that is how the judge saw what happened by looking at the videotape?
That's absolutely correct. And I think when considering what's preserved and what's not, I think the court teased out sort of a tension in my friend's argument, which is that if this was an explosive jury note, I think that was her term, if this changed everything, well, then certainly it was incumbent upon counsel to say, hey, judge, you previously denied it, but now we have this note. Now these jurors need further guidance. And that's exactly the conversation the judge was having with the parties, both the prosecutor and co-defense counsel. And it wasn't facetious. I mean, the court granted the prosecutor's request for an adjournment to consider whether the court should give the charge. And so I think this court was completely open-minded in light of the jury note, and defense counsel never requested it. So I do think that's unpreserved. But if we just look at the record as it existed, based on the video, based on all the testimony, I think there was no evidence that these defendants experienced any subjective fear. And even if they did, it certainly wasn't reasonable. So I think it's both meritless.
Let's talk about the translation then.
Right. So, I mean, I think Your Honor pointed it out. The judge did give an instruction that was entirely responsive both to the note and to what counsel had requested. So if we start off at voir dire, the court had instructed the jurors, you have to take the interpreter's interpretation every time, you know, a Spanish-speaking juror, prospective juror mentioned it. And there was no issues with that. So now we get to the close of evidence. And let's just ask ourselves, if the jurors were confused about that, if they had forgotten it, if they were disregarding it, what would they have done? They wouldn't have issued a note saying, we can hear some Spanish language that wasn't translated. Could you please translate that for us? They would have just go ahead and returned a verdict based on it. Instead, they say, hey, could you please translate this for us? Because we've heard it and we'd like a translation. That's showing that they understand it. So that's
They understand the judge's instruction.
Correct.
That's the
Sorry,
only
yeah,
thing
they-
that
They
you can
shouldn't,
listen to.
that they shouldn't consider anything. I mean, it would have been helpful, I guess, if the judge said it in the way defense counsel suggested during her argument in those terms, but she did say it was obviously not translated before, so I can't give you a translation now.
Right, that's exactly right. And so had trial counsel said any of the suggestions that appellate counsel said, perhaps the judge could have done more, right? Maybe it would have helped. It depends on what the language was. But what trial counsel said was, I think at this point it's not in evidence at the trial and it should not be translated. And so the court says, all right, then I will say that we cannot translate that. It has not been translated. And then goes on to give the instruction just as proposed without any objection, without any request for further relief. And I don't see how that can be error when the note is not asking about that problem. The note is saying, can we get a translation? The court's obligation is to respond meaningfully. And the court says, based on all the agreement of the parties, no, you can't. And goes on to say, and remind them, you have to stick with the evidence at trial, which in this context, I think clearly indicates the court is saying, you're stuck with the translations you've had, not with this additional language you're asking about. And if there are no further questions, people rely on their brief. Thank you very much.
To clarify, it's the note about translation that we believe was so explosive. And just a few responses to my adversary's points. First of all, beginning with the court's remarks in voir dire, as this court is aware, that's not sufficient to supplant a jury instruction. And more significantly, the court did not tell every single Spanish-speaking juror to listen to the interpreter.
No, wasn't there a jury instruction about translation?
There was not a jury instruction given.
Except because the translator said that it was not going to be a translation of certain testimony in the trial?
During voir dire, the court told some, but not all of the Spanish-speaking jurors, you must rely on what the interpreter says. It did not tell any of the Spanish-speaking jurors, you must disregard your own translations. And I want to say that, again, this is not just my idea of what the court should have done. This is what the model jury instruction says, which is you must rely exclusively on the interpreter's translations. And that's what was missing.
Was there translation during the trial?
There was a very short translation of 3 words in the video. The interpreter said, in their opinion, everything else was inaudible.
Okay. So, and when the judge said you can only rely on the evidence, and this was not translated, so you can't rely on it, you're saying that was not proper?
Yes, it was not clear because it was not saying you cannot rely on your own
She
translation.
didn't say you can't rely on it.
Exactly. And I don't think it's fair to say that this note shows that they understood the law, because if they understood the law so well...
But didn't your client's counsel agree to that response to the note?
So before the court reads back the note, my client's counsel, co-defendant's counsel, and the prosecutor are all speaking at once, and they're all saying very similar things. My counsel says exactly what my adversary just said. The prosecutor actually arguably goes the furthest and says, you know, as much as I would love it, they really can't be using their own stuff. And the court says, okay, everyone was in agreement here. And for that reason, I'd like to add that even if this court were to find it unpreserved, this is a very strong interest of justice case. First of all, the court found on the record at sentencing that this was not deserving of prison time despite being a felony. And also, more to the point, again, everyone here was in agreement. This wasn't like this was litigated and we weren't making our position clear. Everyone knew you're supposed to...
Exactly, and they all agreed with what the court said to the jurors. So I don't know how you can argue now on appeal that that was improper when your client counsel below said, fine, that's okay, let's do that. And I don't know.
Well, the court did not read the full instruction that she planned to give.
Well, but that's not what your client said at the time. Okay, thank you. Oh, I'm sorry, wait, we had one more question. Counsel, I know.
Yes.
Yes.
I'm sorry. I'm just curious.
Of course.
Because again, my experience is more in the civil side, and and based on what I gleaned on the record. In your earlier argument and in rebuttal, you make a point of talking about the model instruction that mandates that they are specifically required or mandated only to listen to the translation pursuant to a model jury instruction. Was that requested in your request to jury charges?
I don't believe we requested that. My point is just that it's not like defense counsel is coming up with a crazy idea of what should be said.
No, it's not crazy, but you're saying she should have given a charge that you didn't request.
We requested for the jury to be told to disregard their own translations, and that's what was not given. We didn't say...
It wasn't in the words you like it, but they were told that this wasn't translated, so you can't...
But it seems so apparent to me that they did rely on their own translations, because if their own translations didn't matter, why did they need to ask that question and then immediately come back with a guilty verdict?
Okay, thank you.
Thank you.
La Cruz versus Memorial Sloan Kettering.
May it please the court, I am Martin Adams, counsel for appellants. I respectfully request that the branch of the trial court order that granted summary judgment in part to plaintiff respondent be reversed and plaintiff respondent's motion be denied. And in addition, our motion should have been granted in its entirety. Plaintiff completely failed to show entitlement to summary judgment on any of its claims.
Well, so we have 241-6 and 200 that we're dealing with here, right? That's
Yes.
So the 241-6, there's only one industrial code provision that really is still active here, right?
Right.
And that talks about passageways, right?
I'm sorry, passageways. Yes.
Passageways.
Yes.
So I know we have this Quigley case out of our court from 2018. So is it your understanding from that case and anything that's come before it that a passageway as referred to in industrial code, what is it, 23.1.7 E1, yes, has to be something that's inside, it can't be an outdoor situation, and part of your problem is that this where this plaintiff fell was actually outside on
On a setback.
setback.
Yes, this was a roof setback, which was outside, open air, as plaintiff agreed. And yes, because it was outside, it was not a passageway. It did not have any of the characteristics of a passageway, especially as,
We're not talking about D, the regulation D. We're only talking, plaintiff was only putting forth E1, right?
only E1.
Okay, so let's assume that E1 has to be inside. What about Labor Law 200?
Labor Law 200, the trial court made a critical mistake, in my opinion, and respectfully. The trial court held that because the drainage pipe was installed before the concrete pour, therefore defendants had notice. The key error is that plaintiff is not claiming that the mere existence of the drainage pipe was a defect or a hazard.
It was a drainage hole, right? It was a
Drainage
hole,
correct,
not a pipe,
correct.
right?
Well, yes, correct, a hole. Plaintiff is not saying that, so the court erred in that regard. Plaintiff was saying that there was a failure to have a cover on the hole, not that the hole itself was,
Did you show that there was a cover on the hole?
at the time?
Yeah.
At a specific time,
Yeah.
we didn't have proof, no. But
So it's you're moving for summary judgment, right?
with respect to us, but also plaintiff moved for summary judgment, and plaintiff was granted
Into summary judgment on
Because
200.
The plaintiff said that there was testimony, the hole was there for weeks.
I mean, he's relying on constructive notice that the drainage holes were there because the concrete had been laid and there had been drainage holes that were left out. They should have been covered, and somebody was from Turner had testified that they were obligated to walk the site every day and make sure everything was safe. So if this had been there for weeks, how did they not see it wasn't covered?
It wasn't there for weeks. There's no proof to that. In fact, the plaintiff's counsel at the deposition of defendant cross-examined the defendant at the deposition, asking about this log of the defendant, which said it was covered. And I cited in my brief, plaintiff argued that it was uncovered at the time. Plaintiff himself said he didn't see the hole beforehand. Plaintiff's coworker Murphy did not see the hole beforehand. Plaintiff testified that he had no knowledge of any further accidents or any other problems. The problem that plaintiff had is that he is working backwards. Because the hole was allegedly uncovered at the time of the accident, therefore it must have been covered for weeks.
You mean uncovered for weeks?
Uncovered for weeks, yes, thank you. But presumptions do not work backwards. Presumptions work forwards. Plaintiff offered no proof in his motion for summary judgment that the cover was not there for a sufficient amount of time to allow defendants to know and rectify. There's no proof that this particular alleged defect was known to defendant or the location. Therefore, plaintiff's motion should be denied. In this case, I respectfully submit, should be sent to the jury on the issues of 241 sub 6 based upon 1.71, which is the one at issue, and 200, as well as common law negligence. And I ask that the court reverse the trial court order in that respect. Thank you.
Thank you.
May it please the court, my name is Scott Singer. I represent the plaintiff.
Yes, so let me ask you this one. So we're talking about Labor Law 200. What evidence on your motion for summary judgment did you put in to show that the hole was uncovered and it had been uncovered for a significant period of time?
Well, we put in the testimony, first of all, that this had to be, the opening had to be, the drain had to be placed before the concrete was poured. So there was a lapse of time. This concrete was totally cured. They were putting heavy machinery on it.
There was testimony to that effect, that there was a hole.
There was testimony that...
But the question is, what is the testimony about covering the hole? What evidence did you put in that the hole wasn't covered?
The evidence is on the date of the accident.
Oh, but you're relying on constructive notice, right? For your summary judgment motion.
Yes, indeed. We are relying. But I just
what did you put in on your motion for summary judgment?
Putting in the report, the accident log on the date of the accident said, why did the accident happen? Roof drains not protected with plywood protection. How are we going to prevent from happening again? That was the second question. Situational awareness carpentry subcontractor to fix this particular issue as well as other areas on all roof setbacks as well.
Yeah, but how do you know that there wasn't a cover on it and then that morning someone pulled the cover off? Or 10 minutes before the accident?
Nobody ever saw, there was no testimony ever of it being covered. There was no
Yeah, but
evidence.
that's your point. That's your burden to put it. If you want summary judgment, it's your burden to show as a matter of law that that hole wasn't covered.
It's, as you say, it's a constructive notice presumption. There was no evidence that it was ever covered. These things were uncovered when they were put in. There was no testimony from any individual or anything in the records that we were provided. We don't have all the records. From the records we were provided, there was absolutely no indication that these were ever covered. And
Did
clearly,
they put in any? Did they put in any records in response to your motion to show that yes, they were covered? I know there were pictures that when you went back a week or two later, they had these very pretty covers on them, but that was afterwards.
Exactly. Afterwards, they would put the covers on, but there was no evidence. And clearly, from their accident report, there was no covers on at the time. And
they were trying to figure out how to prevent this from happening the next time.
right. So they said, come on, all those things that we've never covered, let's cover them now. And by the way, we put in our papers, we said, it is clear from this evidence that they were never covered, and they never disputed it in their papers in Supreme Court. They never attempted to dispute that. We said it was uncovered, it was never covered. They did not refute
Yeah,
it.
but what
They
did you
went on-
say it was? What evidence did you put in to show that it wasn't covered for a significant period of time? That's what I keep asking.
Well, it's basically what the judge relied on. They said these were uncovered at the time they were installed. The concrete was poured, and there was no indication that
Because there was testimony at how they were poured and what happened.
that was the sequence, and that's what he relied on. You know, they had to put in these structures, the drain pipes or whatever they were, the drain openings, and they had to be put in before. And there was no indication from anybody, anytime, and
That they
we
were ever
specifically
covered.
alleged it. We said it was never covered. They did not refute it. They did not attempt to refute it. They made all kinds of other arguments.
So you were relying on circumstantial evidence, really? I mean, inferences to be drawn from facts that are not disputed.
Well, it's constructive notice, and
Constructive notice, but a subcontractor put in the drains, then the pour took place. That had to take place over days and weeks.
Right.
And you say, based on the fact that the drains had to be put in uncovered,
right,
based on the fact that Turner had their own information that said that they're supposed to check all this, so there was a protocol.
Exactly, Judge Shulman. That's the basis of it.
Those are the reasonable inferences.
Yes.
I was just going to say, didn't your client and another worker testify that they never noticed these holes?
They did say they never saw the hole. They never noticed the holes.
Mhm.
So I mean, I don't know what we're supposed to do, you know, in this circumstance. They never put in holes. And then we challenged them. We said it was never in, and they didn't dispute it. They said, well, maybe they were in, but maybe there were no coverings, but you never proved that they didn't know it. I mean, they had inspectors going on every single day.
Can
How
I
could they
ask you
possibly
one other question? I know your time is up, but Judge Scarpullo said I could ask the question. On 241-6, the judge also granted you summary judgment on 241-6.
Right.
But although I agree that there was all kinds of construction material and the area was very, very narrow, how do we get around Quigley on 241-6?
Yeah, I mean, I did address it in the brief, and you know, there was a case. I argued that case Conklin goes back from before Quigley.
Before Quigley.
Before Quigley, where there was a they called it a chicken ladder that was constructed. It was clearly outside. In addition, there were two cases that said that an outdoor staircase, an exterior
Yeah, but that's
staircase.
under D, not E1.
But
Yes, it means something. It does mean something.
Yes, that's correct. But Quigley turned on the definition of passageway. And the definition of passageway, the term appears in both D and E. Nobody is saying that
E
there's
is a different section.
What?
D, you said 1.7D, did you mention subdivision D? That's different than here, we're only talking about E1, right?
No, but you can't have a
But a
passageway.
passageway, apparently passageway in D is considered differently than passageway in E1, which I know what you're saying is, does that really make any sense?
Yeah, what I'm saying is Judge Tom, when he wrote the decision, he said, well, this is what a passageway is. He wasn't saying that passageway means one thing in D and one.
No, what he did say, though, was in the context of outdoor, that it doesn't apply. It's not a passageway,
But
right?
as I said, in
particularly as to E1 specifically.
yes.
I mean, it's straight up. It's a.
I understand what I'm up against, but I'm also urging the court to consider what the term passageway means, and that there are.
It shouldn't be. It shouldn't. We shouldn't have it differently for every section. Is what you're saying?
I'm saying it's a passageway is a passageway.
Passageway. Okay.
Regardless if it's D or E, and this court has said at least 3 cases that I know of that an outdoor stairway.
In the context of D, I agree. In the context of D.
Just what does the word mean?
Okay. All right.
Thank you very much, Your Honors.
Counsel?
Plaintiff's counsel cross-examined at the deposition my client's representative. Question, this is page 372. Question, now, do you see that there's a column on this site safety manager's log under the category surface item number 12 that reads, openings and/or holes in the floor are covered and properly labeled? Do you see what I just said, what I just read? Answer, I see it, yes. In addition, at the time of the accident, it was raining out, according to plaintiff. The drainage hole was doing what it's supposed to do on a rainy day. For that additional reason, it cannot be a hazard because it was.
Well, are you talking about it was integral or something? Are you making that argument here?
Yes, that's another argument.
Well, it could still be covered. It doesn't have to be covered, covered up so that you can't.
And have drain.
They could have like little holes.
With holes in it.
We haven't. That's what
Like that pretty little cover that was over it in the other pictures.
And for all these reasons that we've discussed today and in our briefs, I respectfully ask that the plaintiff's motion be reversed, and this case, and the trial court order be reversed. The plaintiff's motion be denied. In this case, be sent
Counsel,
to.
just
Counsel,
one quick question, if I may.
Yes.
Just with respect to the size of the drainage hole, Mr. Clancy, who's a former Turner superintendent, testified that the drainage holes at the premises were 8 to 10 inches wide. And I believe that plaintiff and a coworker testified that the drainage hole was approximately 6 inches wide. So are you saying that a drainage hole that's that wide did not have to be covered, that because it served a purpose?
No, I'm not saying that. No.
Because that's a big hole.
Well, it was 6 inches, my understanding from the record. No, I'm not saying that in no
6 or larger.
I'm not saying that in no circumstances is it to be covered. No, I'm not saying that. And I ask that this case be sent to the jury. Thank you.
Thank you.
I'm going to make a correction to this statement.
No. Thank you, Bill. Park West Executive Services versus Gallo, Vitucci, and Clark.
Afternoon, Your Honors. May it please the court, my name is John Pontero, and I represent the appellants in this appeal. We believe that the lower court erred in granting the respondent's 3211 motion to dismiss, incorrectly holding that the appellant's claims were too speculative because they relied on conclusory assumption that the court in the underlying action would have found Margaret Rivera, a co-defendant, to be an independent contractor. However, the court failed to analyze the factors concerning independent contractors and disregarded the independent owner-operator agreement that was signed between the parties.
This is a pre-answer motion to dismiss.
It was a pre-answer motion.
No discovery.
No discovery.
Okay.
Yes.
And the contracted issue says that she's an independent contractor.
That is correct, Your Honor.
Okay. Well, we've gone both ways on this, right?
There are some cases on both
We
ways.
just had argument on a case where there is a dispute as to whether or not someone, it's a very fact-intensive discussion, right?
Yes, it is, Your Honor. And we believe that.
So you would have to prove to go for, to, on a, say, a summary judgment motion, you would have to prove that the court would have found her an independent contractor.
That is correct, Your Honor. Yes.
Except if you knew that the defense, I mean, there were reasons to waive that argument, right? Do we not agree that there are reasons to do that?
Well, I don't think that they were, if there were reasons, I don't think they were valid as far as Park West
Well, we don't
goes.
know, we don't, because it wasn't argued.
Yeah, it was not.
Wasn't, I mean, isn't there a note that in subsequent cases, courts have rejected the argument that plaintiffs' drivers were in fact independent contractors and found that they were vicariously liable, drivers of Park West Executive in other lawsuits?
Your Honor, the lower court did say that phrase, that there were subsequent cases, but there was only one case that was relied on. It was a case from Supreme Court in Westchester County.
Judge Lubell's decision.
That's correct, right. Which was in 2024, and we're talking that's 9 years after the malpractice occurred in 2015. And that, although it was a Park West case with a driver.
Counsel, I'm sorry. What about Judge Capello's, it could be construed as dicta in the underlying action that led to this legal malpractice claim. He makes a point of acknowledging that the discovery in that case produced documentary evidence where one could argue that Ms. Rivera, the so-called independent contractor driver, had her taxes withheld as an employee, and that there was indicia, documentary indicia of an employee relationship. He noted that, didn't he?
He did, but that was completely factually inaccurate, because in her testimony, in Ms. Rivera's testimony, she initially testified at the deposition she didn't know, or she thought she got a W-2, but then when she corrected the testimony, she said that she got a 1099. Park West subsequently produced the 1099 that they issued to Ms. Rivera. So I think the lower court's decision in the underlying case was factually incorrect at that time.
What about the notion that the primary carrier for Park West, the insurance coverage would have covered someone such as Ms. Rivera, who was not the owner of the vehicle and was a person as defined in the liability section of the policy, which would make her being an independent contractor or an employee relevant in terms of coverage. If that's the case, then the whole claim of the but-for analysis really goes bust, or no?
Well, I don't think that is accurate. I think that the definition of who a covered person was clearly excludes the independent contractor, Ms. Rivera, as well as the co-defendant who owned the vehicle himself.
But let me ask you this: don't you concede that if that defense was waived, and that would take punitive damages off the table, right?
That would take punitive damages.
So it's not like the law firm was coming out of the.
I misunderstood your question. You're saying if the independent contractor claim was waived, that would take punitive damages?
Yeah.
I do not believe that is correct.
Why don't you believe that is correct? You can't get punitive damages on a respondeat superior claim, right?
Well, actually, the court.
Isn't that exactly why?
But the court kept that claim in for saying that it was going to be treated as a punitive damages claim.
Because of gross negligence.
Because of gross negligence,
But
it was still paid.
I guess what my point is that there's a strategic reason to do it.
Your Honor, I disagree with that, and the reason for that is that if they were found to be if she was found to be an independent contractor, right, there would be no liability. They could assert the negligent hiring claim, but then they would have to show that they There was evidence that Park
So
West had
let me
knowledge
just
that she had
interrupt you
caused
for a
the.
second because your time's up and I just want to get to the crux. You're saying if they had waived independent contractor and the only claim was under respondeat superior and there was no, it was only a negligence claim, they would not have begotten punitive damages. Isn't that correct?
That's correct. They would not.
Okay, that's exactly it. So there is a strategic reason to keep it at respondeat superior. Whether or not you agree with it, whether you think it's a good one, there's a strategic decision, right?
Well,
But they didn't argue that.
they
I
did not
agree.
argue that.
I
They
agree,
waived
I
that
agree.
decision.
Okay.
They waived it. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. I do think that the Supreme Court here got it exactly right when it dismissed the complaint, because essentially what the court held and what the essence of this case is, and in a lot of these legal malpractice cases, as the court is aware, lives and sort of dies on these causation and the but-for causation analysis. And
Most of the, let me ask you, let me start
Yeah.
with this. Whether someone's an independent contractor or a special employee is pretty fact-intensive, right?
generally speaking, yes.
And in this case, there's been no discovery as to whether or not that defense should have been waived, right?
There's been no discovery, but even with that being said, it's the issue as to why the lower court dismissed it is predicated on the notion that had the issue of independent contractor or employer-employee been litigated, the court would have found that Ms. Rivera was an independent contractor.
Without any discovery? How could any court have decided that issue without any discovery on it?
But I don't think that the discovery.
I think that's not what the court said. The court said it would be too speculative.
Right, the court said that
decide
plaintiff's
in the-
allegations
right,
that
to
had the defendants not allegedly conceded that Rivera was an employee of Park West, they would not have suffered damages, relies on the conclusory assumption that the court would have
Right,
found
exactly.
that she was an independent
so
contractor.
The question then becomes, is that a conclusory assumption? And on a pre-answer motion to dismiss, but before any discovery is done on that issue, it's hard to say that the only evidence we have is a contract that does call her an independent contractor.
Well,
I'm not saying you wouldn't win on summary judgment, but what I'm saying is this is a pre-answer motion to dismiss. And the one fact that we know from the complaint is that the parties to that contract agreed that she was an independent contractor.
And the lower court addressed the issue of whether or not the independent contractor agreement in and of itself is not a dispositive
This
issue.
is a summary judgment motion. That is my whole point. This isn't a summary judgment motion.
And
It's
I
a
don't think you need to do discovery to conclude that the allegation that they would have found that she was an independent contractor, it is not, it's an issue that is ripe for 3211A7 because it is inherently conclusory and speculative for the plaintiff to assert that the court would have found that she was an independent contractor. And that's the point. I'm sorry, yes,
Can
Your
you
Honor.
address the conflict of interest of the firm representing all the defendants in this case?
Sure. I think ultimately the issue of whether of the conflict of interest is ultimately immaterial, and here's what I mean by that. I'm not discounting the notion of conflicts or the seriousness of that issue generally. But ultimately, if, let's say there was separate counsel that was appointed at the outset, it doesn't change the fact that they would have set forth potentially the argument that Ms. Rivera was an independent contractor. The fact remains, and the record in her testimony from Ms. Rivera is clear, that there are clear indicia of there being an employer-employee relationship. So the fact that there was a conflict ultimately doesn't change the fact that there would have been a finding, or at least a question of fact, that she would have been deemed to be an employer-employee, or a question of fact. These are routinely, the but-for causation arguments are routinely decided on 3211A7 motions.
If the court had found that, if a court eventually found that she was not an independent contractor, or that she was an independent contractor, as opposed to not being an independent contractor, right? If a court had found that, and you waived that defense, you're saying that would not have been malpractice?
I don't think I'm saying that if I'm understanding
You're
your question
saying
correctly.
that there's no possibility that any court would ever have found her to be an independent contractor.
Oh, no, I'm saying even if,
So if that's exactly it, I'm saying to you, if a court found that she was an independent contractor, but you waived that defense so you couldn't assert it, doesn't that show causation? Because the insurance companies wouldn't have had to pay anything if she was an independent, or may not have been able to.
well, I was going to say, because there's still.
Right, I agree, right, but
cover,
that's something.
the
right.
issue on the coverage. But I think if we're talking and articulating the parade of what would have occurred in terms of whether she would have been deemed to be an employee or independent contractor, or there would have been a question of fact, that is the definition of what would be speculative and conclusory as it relates to the allegations of legal malpractice.
Right, so, but that is my whole point, that there would be but-for causation if in the underlying action, they found her to be an independent contractor.
Right, but I don't think that's how we have to look at it in the context of the legal malpractice case, because it's as the court held below that they would have to prove that the court would have found
Right.
that they were an
But they have
independent
no, they've
contractor.
got nothing at this point because there's no discovery. Maybe they can't prove it, but how do we know?
We have the record replete with deposition testimony in the underlying, which we set forth the factors that are indicia of employee-employee relationship. But the fact
We
that she
don't have
could
that
have,
in this action, right?
it's part of the record in terms of what was done below. I mean, that's the testimony from Ms. Rivera. That's going to be true today as it is in 2 years.
Okay,
Thank you, Your Honor.
So, just to follow up on the conflict of interest, that when the motion was made where they waived the independent contractor defense, that the respondents were at that time representing all three parties. So it was a clear conflict between not only Ms. Rivera, but also Park West, to put forth that theory, which clearly, when they waiving the defense of independent contractor, clearly helped Ms. Garcia, I'm sorry, the driver. And in no way did it help Park West. They didn't even ask for their permission to withdraw it. I have no further questions, then I'll
Thank you.
submit. Thank you.
Thank you. Willis Stanley Walker.
Last but hopefully not least, may it please the court, Vincent Chirico for the plaintiff appellant. The parallels in this record are so rampant and damning. They clearly show, at the very least, clear and convincing evidence of fraud, undue influence, duress, that in this procedural posture, which was a motion to dismiss, should have been denied. There's no question, and the respondent admits that Mr. Walker had a stroke. She describes it as a very slight stroke for which he received at least 7 months active medical treatment, 3 months in 2 hospitals, 3 months in a rehab facility, and after that at home in Miami getting active treatment. In the midst of all this, he executes a will that disinherits his sister, the appellant, his only sister, and devises...
When was the last time he had any contact with his disinherited sister? Decades, wasn't it?
It had been years. It had been years.
So, I mean, 3 separate times he made it abundantly clear. He put it in more than one place in the will, as far as I could tell, right at the beginning, in the middle, and the trust, that she was disinherited. He's leaving nothing to his sister or her children because they had no relationship. So what makes it abundantly clear that that was some type of fraud? I don't get it.
Well, 2 points in response to that question, Your Honor. The first one is that this will that says that is executed at the same time that he's getting active treatment for a stroke.
But no, you're not seeking to vitiate that. You're seeking to vitiate the last will. The last will.
Which is the only one that counts.
Except no, if you vitiate that will, the will before it counts. And that will also disinherited her. So even if we agreed with you that that last will was at a time where he didn't have testamentary capacity, which, I mean, I'm not saying that we do agree with that, but even if we agreed, then the last will is out, and he has no interest, she has no interest under that will either. And you're only seeking to vitiate the last will.
Well, you're absolutely right, Your Honor, except for the fact that all three wills were executed one after
You are not seeking, we're not talking, you are not seeking to vitiate the other wills, only the last will. I made my, and you, we have to agree on that, right?
Yeah.
So even if we took out that will, your client is still disinherited.
Well, if you vitiate that
And then
will,
she doesn't have standing because she's disinherited under every iteration, the two previous ones.
Well-
That's why my colleague kept asking you. It's not just one will, it's several wills. So when we get rid of one, the one before it stands, and that will says she's disinherited too.
well, given that the last will revokes all prior wills, if you
No, the way it works is if you get rid of that will, then it's the will before.
under which it's still a
She's
case.
still out. She's disinherited on the previous will. And if you get rid of that will, the will before that disinherits her. I didn't make up, that's what the law is.
I understand, Your Honor. However, as an intestate,
No, it's not intestate. It's the will before is the operative will.
she is under 411, she is an intestate
But
beneficiary.
she's not, that's the whole point. The decedent isn't intestate. The decedent has a prior will that becomes the operative will. That's the way the trust, the state's law works. So she's not, it's not an intestate situation. He's got a will. The previous one is the one that works.
Well, we submit that we still have standing under those
How?
circumstances.
Even under the, if we get rid of the one that you're seeking to vitiate, the one before it is the operative will, and she's disinherited in that will.
Well, given that she discovered the fraud back in 2021, years later, the only issue in the lower court was whether she executed the waiver and consent knowingly. Since she did not know the process of all this, at the very least, on a motion to dismiss, she should have been able to challenge that will and enter into facts determining whether the prior wills did in fact apply.
Was your client given the name of the attorney handling the estate and the opportunity to call and ask questions before signing?
No. She was
So
told,
that email in the record that says, here's the estate documents,
Here's the
here's the name of the lawyer, that was made up? It's like an AI hallucination?
which was after the fact. That was done after the fact, according to this record.
All right, thank you.
Thank you.
Good afternoon, Your Honors. Christopher Melito of Morrison Cohen for the respondent. I think the court has really seized upon one of the main issues here, which is the successive levels of testamentary capacity that the appellant would need to prove in order to become a intestate distributee.
Well, she's not seeking to invalidate the earlier wills.
Precisely.
She's only seeking to invalidate one will, one trust and one will.
Right.
So if she does that, even if we agreed with her, that all that means is that the previous will would be the operative will. She's disinherited under that one, so she has no standing, right?
I agree, Your Honor, and I think that alone resolves.
And just to tie it up a little bit, each of those wills, putting the last will aside, had attestation affidavits, which means witnesses were in a position to determine whether Mr. Walker was sane and competent to make those respective wills.
That's correct, Your Honor. And as the court is well aware, bearing those attestations, these wills are presumed to be, there's a presumption of regularity in their execution. And the number of years after Mr. Walker's passing that have elapsed since that time, it's been 6.5 years, and now suddenly in 2021, He
Well,
expired
it
in
seems like a lawyer in Florida for the person with who the trust was trying to foreclose a property was the one who told her about the size of the trust, right?
Correct, Your Honor. And yet there's still a delay in bringing an action to unwind the probate of the will, which happens after the petition to challenge the trust. There's no reason to have rested on appellant's rights, whatever they may be, when she knew, or presumably was aware in 2021 of what she believes is fraud. Now, we shouldn't.
When did the decedent pass? In 2015?
2015, right?
2015.
Right.
And at that time, the trust documents were part of the probate file?
They were part of the probate file because this is a pour-over will. Everything from the will went into the trust. Granted,
And was there anything stopping her from looking at those documents?
nothing at all, Your Honor.
As a matter of fact, you put into the record that testimony that you in fact made her aware of it before Ms.
Jurasovic?
Yes, went up to visit with Ms. Mecca to get her to sign the documents. That you said, here's this information. If you need anything more, let us know. Here are the documents. She said those were created subsequently.
That's an important point, Your Honor. I think it's something the surrogate's court seized upon in its decision. The appellant took the position in the court below that she had already signed the waiver and consent prior to receiving the will and the trust documents. But the documentary evidence flatly contradicts that. And Surrogate Gingold completely seized upon that and said, no, you had them before and you signed them after. Clearly.
But I mean, even if she did get them after, she got them soon after, right? So she could have
She got them before.
Even
I mean, assuming that, assuming without, right, the evidence seems to show that she got them before. But even assuming that she got them right after she signed the waiver, she got them right after, and she
Not 6 years
not
later.
6 years.
Within days, according to appellant's testimony.
Right. Okay.
Speaking to appellant's testimony, and this is, I do want to be clear that there's the issue of testamentary capacity, which is one, and there's the fraud question, which really goes to the.
Counsel,
Yes,
I
yes,
have a
yes.
question with respect to testamentary capacity. So there's reference in the wills and so on about the lack of a relationship. Is there anything to the contrary, for example, where the sister said, oh, no, my family and I, we were always there. We saw him. He just doesn't remember. He's not well. A doctor went to see him because he forgot about us.
No, not at all, Your Honor. In fact, appellant's testimony in her affidavit confirms the lack of her relationship with the decedent for decades, which also calls into question any allegation or personal knowledge she had as to testamentary capacity. She hadn't seen him in decades, is relying on the fact that he did suffer a stroke in 2012, yet executed successive wills after. The surrogate's court found that less than speculative. There's no reason to unwind that decision, Your Honors. Thank you for your time.
What we have in Ms. Mecca's affidavit was that she first discovered the fraud in 2021. There's no questions of statute of limitations. The petition was brought timely.
The 6-year statute had run, right? This
No.
is only.
No.
This is, I think it had run. I think you're looking at a discovery rule.
Well, it's a 2025 will, and she discovered it in January 27th of 2021.
When was her lawsuit commenced?
In 2022, April 2022, I believe.
And it was 2015, so that's 7 years.
Yeah.
So that's, the statute has run. It's a 6-year statute. You're relying on the discovery rule, aren't you?
Well, I'm relying on two things. I'm relying on the discovery rule. I'm also relying on the Simkuski case that holds that a party may be equitably stopped from pleading the statute of limitations where she has induced the petitioner by fraud,
Well, that's
misrepresentation,
generally
or
the
deception.
discovery, that's the same thing.
Yeah.
Right? But the 6-year statute had run. So you're saying that I was lulled into believing
That's right.
that my brother, who I understood to own a lot of property and was a successful businessman, didn't have an estate.
Yes, I was induced into saying that not only did he have no assets, but that his estate would have a hard time paying taxes.
Was there anything to prevent her from looking at the documents herself?
No.
She could have looked at every single document herself and decided whether or not that was true.
Yeah.
There was nothing
All we have
preventing her
all we
from
have is
doing
the affidavit that she relies on.
Okay, all right,
All right.
thank you.
Thank you, Your Honor.